Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. Now say the Commonwealth of Massachusetts, court is open, please be seated.
See if I can organize that. Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. I am very lucky to be joined today by two outstanding colleagues. To my right, Justice Sachs, and to my left, Justice Smyth. We will be hearing, I think, 6 cases today. When we get to them, 2 of them are related cases, and we'll figure out what to do about that. In the meantime, though, the rules are as they always are. It's 15 minutes per side. There is no rebuttal. And we have read the briefs with some care and are familiar with the facts, and given the short time, you may want to get right into the argument, but it is your time, and if you don't do that, that's up to you. And with that, we will hear first number 25464. This is MDU Restaurant, Inc. versus Judy Chen, and we will hear first from Attorney Milgram.
Good morning. Good morning. For the record, my name is Attorney Jack P. Milgram, and I appear here this morning on behalf of all of the defendant appellants. We have before the court this morning my client's appeal of a judgment that entered against them in the Superior Court of Norfolk County. The record in this case is clear that if an individual or an entity wants to demolish a commercial kitchen, a restaurant kitchen, municipal permits are required. A building permit is required for the actual demolition. An electrical permit is required because all wires need to be capped because of the risk of fires, and a gas permit is required because all gas pipes need to be capped because of the risk of explosions. The record in this case was also clear when we look at the commercial lease between the parties that at all times material during the entire 10 years of the lease, including the last 2 days of the lease, that if the tenant was to take any actions that required permits, that permits were required.
Counselor, could I ask you, before you continue, because I'm not sure what you said thus far relates to really what we're here on. What issues are we properly here on today? I mean, we're here on Judge Canoni's finding of damages, correct?
There's 2 issues. Well, there's 3 issues which were raised in the brief. Judge Canoni's finding of damages, number 1, whether or not it was proper for Judge Miller to issue the preliminary injunction.
Well, let's stop there for a moment on the preliminary injunction.
Yes.
Did you properly support the record with any hearing or any transcripts from the preliminary injunction? That's the first question. You have an obligation under the rules to support the record, to add to the appendix, for instance, a transcript of the hearing. Did you comply with that?
I did not provide a transcript of the hearing.
Well, let me also ask you about the timeliness of your appeal on the preliminary injunction. You moved to vacate it or to nullify it before, was it Judge Miller?
Judge Miller issued the original injunction, that's correct.
And you moved to reconsider or to, again, vacate it, correct?
We did various different things. We filed an appeal with single justice, which was denied, reserved until after trial. We filed a motion to vacate it for Judge Rivera, who said she wasn't going to get involved with that.
So after she made that decision, under the rules, you have 30 days to appeal that, correct?
We did a single justice. We attempted to do a single justice appeal.
Well, that's separate. Single justice is different. I don't want you to spend all your time on this, but I'm not sure that's properly before us, because appealing the dissolution or the vacation of that order, you would have to appeal within 30 days. And I guess the third issue I have with preliminary injunction, again, I don't want to take up your time on this issue, which may not be properly before us. Isn't it moot because there's been a final judgment?
I would say it's not moot, because if you take a look, the reason why that's partly critical to the appeal is if you take a look at both Judge Canoni's decision after trial And if you take a look at her decision on the award of attorney fees, it's more than clear that she took into great consideration the violations of the injunction. And of course, our position is that injunction never should have issued in the first place. And if the court were to find that it shouldn't have issued, then I think both the trial court decision as to the trial and the attorney fees would have to be vacated, because we don't know what Judge Cannoni would have thought if that wasn't properly to be considered. And it was clear, it was argued at the time in 2018 that there was an adequate remedy at law.
Can I just ask about if we were to vacate it? If we were to hold that the injunction wasn't properly entered, does that make the sanctions for violating it while it was in effect go away?
I would argue that it would, because it never should have issued in the first place.
Okay, but the presumption is, or not the rule, is that parties have to obey orders unless and until they're overturned on appeal. So even if you get it overturned on appeal, what case says that the contempt sanctions ordered in the meantime don't stand?
Well, even if those sanctions were to stand, the issue is more than just the sanctions for that. Because as I've indicated, both in the trial court decision after the trial and the attorney fees, she talks repeatedly in regards to that.
Right.
So
well, I saw that she backed,
it affects everything from our perspective.
I saw that she backed the compensatory aspect of the contempt sanctions out of the final damages award. I think the plaintiffs had made two $5,000 deposits on contracts to move out that they lost because they couldn't do the move out, and she ordered that as a contempt sanction, but she backed that out of the final damages.
I understand that, but the problem is when you read the decision in finding double damages on 93A, she considered that. In addition,
for the willfulness, you mean?
For the willfulness. In addition, in regards to the attorney fees, we made an argument where she acknowledged that we felt that 4 times the amount of damages on attorney fees was excessive. And we talked about the fact that we didn't consider this to be an extremely difficult or complex case, or a case that was particularly of the public interest. And in her decision, she said, yes, I don't disagree with the defendants that this may not have been a particularly difficult or complex case, but she said that she was going to award the attorney fees because I found that they didn't comply with the orders.
Counsel, how are we to rule on attorney's fees where you didn't provide a transcript of that hearing you're referring to? You haven't provided any invoices that may have been submitted. We have nothing in the record you've presented for us to evaluate.
Well, then I'm going to focus on, I'm going to go back to the first argument because I got 8 minutes and 18 seconds left, which is whether or not the court should have awarded any damages. So if I may, I'm going to go back to where I started, which is that the record is clear that you have to have the permits to do.
Okay, so you
what they
didn't
did.
raise this argument until oral argument on summary judgment below. It's not in your papers below that I've seen. It's not in, it's not the reason you initially gave for having locked out the tenants.
That was always the reason that we gave.
No,
Going back
the
from
reason you
beginning.
gave was an abandonment of the lease, right?
That was an additional argument.
No,
That's correct.
it was the primary argument, and then eventually you raised these permits, right? It's not raised right at the beginning. Do you disagree with that?
I disagree with that.
All right, I'll look at the record.
I-
Let me
I
ask you
disagree
this.
with that.
You say they did.
That the whole dispute, I don't mean to raise my voice, I apologize.
You say that they didn't have the permits.
Yes,
The judge found they had paid a contractor $5,000 to move these things out.
the judge found on May 30th, 2018, one day before they vacated, that they had no permits. And there was no testimony, and there's never been any evidence that on what would have been the last day, May 31st, that they would have had any
The burden
permits.
is on you, not on them.
No, permits are on them.
Tell me how the burden is on them. You lock them out and say they don't have permits.
Correct.
But you didn't let them move out. We have no idea what would have happened the next morning. Maybe they would have pulled all the permits. The contractor coming to do it, I don't have the first idea. So
There was no evidence to that. You have the transcript of the trial, and there was no
Okay.
evidence at the trial
okay,
that they were
but
going to have the permit on the last day.
we are talking about your locking them out, right? And you're saying no, a but-for cause of this failure to move everything out was that they didn't have permits, right? That's what you're saying.
That is correct.
Okay, but we don't know. Now we have to speculate. Would they have had permits? Would they not? How are we supposed to figure that out?
Because we have a trial transcript, and we had
Did
multiple
you
days
ask
of
them?
trial.
Is there evidence where they said we intended not to get any permits?
There was no, they didn't answer. I inquired. It's in there, in the transcript. Of course I asked them.
In the
They
transcript?
avoided answering, because obviously the answer was going to be no. And I also think we know that they weren't going to have permits, because it's also in the record that when they went there on August 10th, after the hearing on the contempt, to try to take the equipment out, they still didn't have permits.
That's a different question, right? That's a different question than speculating about what would have happened on the final day of their lease. Let me also ask you this. What makes you think that the food would have been locked in there? First of all, I don't know if you need a permit to take the food out.
I'll
but
concede that.
That the food would have been locked in there till September. Why do you think that because of no permits, the equipment wouldn't have been taken out till September? There's no reason to think that. That's just a guess. I mean, who's to say if someone had raised this with them, they wouldn't have gone and gotten permits?
I would suggest it's not a guess. I would suggest that the inference is strong and is reasonable.
That until September, they would never have gotten permits that take 10 minutes to get.
No, I'm talking about the last day. As of the close of business on May 30th.
But the damages flow from your keeping the stuff in there until it was unusable, until they had to replace, until the food had spoiled, right? I mean, all you're saying is that maybe on that first day, there shouldn't be damages. But at some point, they would have gotten permits, right?
The lease expired, we all agree, I think, the lease expired May 31st. That means the last day that they could have legally removed the equipment in the kitchen or the fish tank was May 31st. If they had not legally removed it by May 31st, they would have had no more right to remove it because the lease was over. And as of the close of business on May 30th, they had no permits. And to say that they were going to apply for permits, have permits issued,
I'm not
and
saying
remove
that's
everything
what
in the
happened.
last day,
I'm saying
it's not reasonable.
I'm saying we don't know because of the wrongful action of your client. We will never know what would have happened on the 31st, right?
I have a different opinion. I think the inference is reasonable what would have happened in light of the fact that there was one day left and they had no permits, which the judge found. The judge didn't find that. That'd be a different situation, but she found it.
And did she find that they wouldn't have had permits at the time they went to remove the things
On
on
the
the
31st, the next day?
It's a weekday.
No, she didn't find that.
Okay.
She found there were no permits on May 30th, and she found there were no permits on August 10th. That's what she found, and that was correct. And there was no evidence of any permits ever being applied for at any time prior thereto. The first time they ever applied for any permits to remove anything from these premises was in August, after they went there on August 10th, and the city shut them down. Then they finally went and applied for permits. So it was clear that they never intended at any time to have permits. And they spent a lot of time in their brief talking about the fact, which is correct, that real estate is unique. And my client understands the court found, trial court found my client's very experienced in restaurant business, my client's experience as a commercial landlord, and it was her family's building. And she's very well aware, you don't have wires capped, you don't have pipes capped, you could have a problem.
Is there some simple place we can look in the record to determine that permits were actually required? Because as I looked at the work that was being done, you know, capping a few gas lines, disconnecting some kitchen equipment from the power, is that the kind of thing that actually requires a permit?
If you take a look at the appendix, all of the permits are there.
I see that the permits were eventually issued, but does that mean that they were required?
They weren't required, they wouldn't have been issued. You don't issue permits for work that doesn't need it. And gas pipes do need to be capped. Wires need to be capped. So you don't have fires, you don't have explosions. That's what was on my client's mind.
Well, the judge found that what was on your client's mind was, I don't know what actually, but that the reason given was abandonment of the lease, right? That's what they were told that night. You've abandoned the lease. They weren't told go get permits.
Told the May 30th, when you say night?
Yes.
They weren't told that.
What were they told?
I know what they were told, because as you probably know, I was there.
Yes, I'm aware of that.
I couldn't understand the entire conversation, because most of it was in Chinese, which I do not.
So you don't know what they were told?
I know what I told them. I wasn't a witness in this case, nor do I care to be a witness in this case. But I know what I told them, which was that,
Well, is this in the record?
no, because I wasn't a witness, as I just
Well,
said.
I
right?
don't know anything
And
about
I chose not to
yes.
be a witness at this trial. But that's not what they were told. And that's not in the record, that's what they were
All right.
told.
Well, we'll ask opposing counsel as well, of course, and we'll look at the record.
Lastly, going back to the injunction, I know I'm running out of time, but it's clear there was an adequate remedy, a law, which was monetary damages, which is what the court awarded.
Okay, your
It's
time
improper
has
to issue the
expired.
injunction.
I see
Thank
no
you.
further questions. Thank
Thank
you very much. We will hear from Attorney Winterhalter Millard, I believe.
Just Winterhalter is fine, Your Honor. Thank you. Good morning, Justice Rubin, Justice Sachs, and Justice Smith. May it please the court, my name is Benjamin Winterhalter, and I represent the plaintiffs and appellees MDU Restaurant, the tenant Chinese restaurant, and its owners. We respectfully ask that this court affirm the Superior Court's judgment in all respects and award the tenant its appellate attorney's fees pursuant to Chapter 93A. I trust that the court has read the briefs, and I want to address each of the landlord's arguments, so I will simply dive right in. The landlord argues that the Superior Court erred in ordering her to unlock the premises because money damages would have been an adequate remedy. I just want to note at the outset the single justice decision from Justice Wendland from 2018, which addressed this argument in a single sentence and declined to exercise this court's discretion to vacate the injunction. I don't believe that the defendants ever appealed that decision, so I just would note that at the outset, Your Honors.
So I think your opposing counsel just agreed that ordinarily real estate is unique and that damages might not be available, the damages would not be available, that injunctive relief would be appropriate. What about on the last day of your tenancy where you're moving out? You're not trying to use the real estate for any particular purpose to which its uniqueness might be relevant. So are damages sufficient in this instance?
I don't think so, Your Honor. I think that in this instance, moving out was essential to the tenant's business operations. The tenant had leased a new location, I believe it was in Malden, and that the tenant was in the process of moving all of its food inventory, all of its refrigerators, all of its restaurant equipment. There's a list of various sundry items and a footnote in my brief that also needed to be moved.
In theory, couldn't the tenant have recovered damages for the failure to, the inability to open the business, or if the tenant had to go rent the kitchen equipment from somewhere else until the tenant's own equipment could be retrieved from the leased premises here? Would that, those costs would be recoverable as damages?
I suppose theoretically that's true, Your Honor, but I think it confers too broad a right upon the landlord. I think that it essentially confers upon the landlord a right to ignore summary process and to ignore General Laws Chapter 184, Section 18, prohibiting precisely this kind of extrajudicial lockout.
Do we order the return of property in conversion cases?
I believe in general, no, money damages are considered sufficient in a conversion case, Your Honor.
So
but-
someone can go into someone's house and steal a bunch of their stuff because they like it, and then just pay the value of it to the person.
No, I don't believe so, Your Honor.
Well,
I
then-
think that's incorrect.
Okay, so where, like, what law do you have on this? It sounds wrong to me that you can convert something and then just pay for it instead of giving it back to the rightful owner. But I don't know a case that says that. But again, I haven't looked that hard.
I don't know either, Your Honor. I actually don't know what the conventional practice is in conversion cases. I was simply saying that it seemed to me that a conceivable remedy could have been to award money damages, but I also think that it would be completely appropriate to order the return of an item, especially if it's unique, and especially where there are business exigencies that depend on possession of that physical item, which is in fact an individual's property.
Do you know when the other side first raised the argument about permits?
My understanding, Your Honor, is that it was raised for the first time at trial, and that it was raised via the landlord's testimony concerning permits. I believe that the landlord
So this is after there had been litigation on the injunction?
That's correct, Your Honor.
So it wasn't raised at that point as a basis for it being permissible to have excluded the tenant?
No, my understanding is that on the injunction stage and on the evening of the actual events in question, what was proffered was that the tenant had abandoned the premises, or that the individuals involved were not actually the tenant, that it was a different entity, perhaps some confusion between the DBA and the actual name of the entity that owns this business. But I don't think that any question concerning permits was really properly raised until the trial, which was after summary judgment had established liability under 184.18.
Do you agree that the permits were legally required to do the work that was necessary to get out?
I think I do agree with that, Your Honor, but as Your Honor's pointed out, I don't think we can know what would have happened on May 31st had the landlord, elected not to illegally lock its tenant out. My client had retained a contractor, which certainly would have taken steps to procure those permits. It was a Thursday. They could have been procured on the Friday. It was still a business day. The municipal authority certainly would have been in operation and the permits could have been issued.
Do we know how much of the equipment required permits to move out? I assume you don't need a permit to move your food out.
No, and I think the other side concedes that, and I think that goes to the issue of damages in substance, Your Honor, at least a significant part of it insofar as the Superior Court awarded damages for spoiled food.
And is there anything about what the pieces of equipment are? How many of them are hooked up to things like gas or directly to electricity rather than just plugged in?
There was almost no testimony on that question whatsoever, Your Honor. The landlord didn't call any witness from the city. It didn't call any witness from a municipal authority. It didn't call someone familiar with the state sanitary code or the state building code who could have provided information on, there was no expert testimony at this trial. It was really the tenants and the landlords as the only witnesses. And I think that those aspects of this situation really work against this sort of post hoc rationalization that the landlord has concocted concerning permits. I just want to lay a bit more stress, Your Honor, on the issue of irreparable harm. When the landlord arrived at the police on that night, on May 30th, my clients were in the middle of moving out. They were planning to move to their new location, and that was in fact their reason for having so much perishable food on hand. They were storing it in one location and planning to move it to another. It was full of food. There were live seafood animals in the restaurant. Those animals would not have died were it not for the landlord's actions. And I just want to note the severity of the violation of both ignoring a Superior Court order and eventually being held in contempt of that Superior Court order, receiving no recourse from the single justice of this court. and continuing to sort of hold the tenant's business hostage. As this court already brought up, and as opposing counsel concedes, the right to possession of real property is unique. That is, I think, the whole point of a modern commercial lease, and I don't think there's a sort of end of lease exception to that general principle, that loss of access to the property in general can't be fully remedied by money alone. I think that has to be what the statutory language of Chapter 184, Section 18, providing for enforcement in equity, refers to in this context, where the statute is concerned with illegal lockouts, is not by its terms limited to residential premises. I think it has to be contemplating the idea of injunctive relief, allowing a tenant back in. Turning to the issue of causation, I think we've discussed the issue of permits in some depth, but I wanted to discuss the idea that nothing in the lease gave the landlord the right to enforce suspected permit noncompliance through a lockout. The lease confers certain rights concerning access to the property for ordinary purposes like repair or inspection. What it doesn't do is give the landlord the right to simply lock the tenant out of the premises if the landlord believes that the tenant doesn't have a permit to do something that they're doing. The avenue for relief for there certainly would have been to seek injunctive relief in court. The lease, in fact, required my clients to yield up the premises, and they were in the process of trying to do that exactly when the landlord brought the police. I think the trial judge's findings on causation speak for themselves, and I think they're very clear, that it was the landlord's lockout that caused the tenant's damages. Had she not locked the tenant out, the food wouldn't have spoiled, the seafood animals wouldn't have died. The landlord testified that there were rats in the premises when they went back in, that wires had been chewed through. The electricity was out. That's why all of this expensive equipment failed.
And when you refer to causation, you're speaking to Judge Cannone's ruling on damages?
That's right, Your
Or
Honor.
the summary judge, okay.
That's right. Finally, I want to address the landlord's contentions on attorney's fees. As a procedural matter, I don't think the landlord has complied with its obligations under Rule of Appellate Procedure 18 to provide this court with a record sufficient to assess the issue and allow for any real meaningful review of the amount awarded. You don't have the contemporaneous billing records that were submitted to the court or the landlord's briefing or the tenant's briefing on that issue, so I submit that you actually don't have to entertain this challenge. But nevertheless, I do think the award of attorney's fees was proper. The landlord invokes the American rule to argue that she shouldn't have to pay attorney's fees, but under Chapter 393A, Section 9, fee shifting is mandatory when a willful and knowing violation like the one at issue in this case is found, and it's as simple as that, quite frankly. It's a fee shifting statute. The American rule doesn't apply, or if you read the American rule closely, it says that there's an exception for fee shifting statutes. I also think that this argument ignores the specific findings of the trial court in making the award of attorney's fees. The trial judge said in her findings that the plaintiffs and their counsel, quote, prevailed on all substantive matters, unquote. The judge found that the landlord's conduct was a willful and knowing 93A violation, which I do think applies even in this business-to-business context. And I think the judge properly used the lodestar method in calculating the amount of the fees. And the judge made findings that it was the landlord's strategy of insisting on her correctness about these issues here that really dragged this case out where it could have settled. And I don't think that, the inability of the parties to reach a settlement should be ignored in the context of 93A, where that's broadly the framework that the legislature contemplated for 93A. The trial judge found that it was that obstinate behavior that necessitated so much litigation, and there was no abuse of discretion in her making that finding. Tenants' counsel are experienced specialists in landlord-tenant law, with many charging a reasonable hourly rate for the local market for time reasonably spent in actual litigation. So if this court is inclined to reach the merits of that issue, I do think the award was proper.
Am I right that we don't have before us an invoice?
That's correct, Your Honor. No invoice, no contemporaneous billing records of any kind. So in conclusion, Your Honors, I do think there's sort of a confusing melange of issues or standards of review presented in this case, but to the extent various Superior Court judges' rulings are challenged, I think that each judge who touched it handled it correctly. The injunction was necessary to restore possession, and I do think restoring possession is proper in this commercial context. The damages were the direct and physical result of the illegal eviction, so I think causation is plainly established, and I do think fee shifting is proper under 93A. Therefore, I would ask this court to affirm the judgment in every respect and award the tenant its appellate attorney's fees pursuant to Chapter 93A. Unless the panel has anything further.
Thank you very much. I see no further questions. Thank you both very much for your arguments.
Thank you, Your Honors.
The case is submitted. We are going to next hear number 25-252, Commonwealth versus AYOUB. This is a partially impounded case. I'm not sure what the scope of that impoundment is, but you will be, so avoid impounded material, please.
Thank you, Justices.
And with that, we will hear first from Attorney Goldblatt.
The first issue, which I think will be dispositive, is the question of juror bias. And the juror who was seated, who stated the last thing he said during voir dire was that he might side with the police in the case. And the challenge for cause was made, and he was seated anyway. To me, looking at that, that's the end of this. That's a structural error. You have a juror who confesses bias, and he's seated, and he deliberates.
Can I interrupt you, counsel? Have you read Commonwealth v. Nelson?
Yes.
The facts are very similar. In that case, I think the potential juror said, I think it was he would believe the police may be 51% more. And he was challenged, or excuse me, the judge initially conducted a colloquy and told him he would have to follow her instructions or his instructions. The defendant did not exercise peremptory challenge on that juror, did not ask for more peremptory challenges after the defendant had exhausted their peremptories, and the defendant said he was content with the jury. So we have a lot of similarities with this case. So how is our case distinguishable?
Several ways. The first is that in Nelson, that was a credibility case. So this is not a confession of juror bias directly against or for either side. It's simply a statement that if certain witnesses are going to testify, he might tend to believe them more. And then he's instructed not to, and he agrees that he will not, right? So there's two things that make that different. One is after the confession of potential bias, which is different than actual bias. He's not saying, in Nelson, he's not saying that he's biased at that moment, just that he might become biased. And then there's an instruction and more inquiry. In this case, there's a statement of actual bias. I might side with, and that means that he wants them to succeed, not just that he might believe them more. And there's no follow-up. There's no re-instruction.
Well, we don't know if that's what side with means. He said that he could follow the judge's instructions and evaluate the testimony of the police witnesses the way he would any other witness. And then he says, in response to the attorney voir dire, okay, I might not believe them more, but I would side with them. There was no follow-up on that to try to reconcile what those two statements meant. And that was the defense's opportunity to say, well, okay, you say you wouldn't tend to believe police more, but you tend to side with them. What does that mean?
That's true. Side with has, I think, a clear English meaning. So if he was making a true statement that he would side with them, that to me is the end of the inquiry unless he's rehabilitated.
How do you reconcile it with him saying he could follow the instructions? Or how could the judge reconcile it, and did she abuse her discretion in doing so, I guess is the question.
First of all, I think she did abuse her discretion in saying that somebody who sides with the police is following an instruction to be fair and impartial, right? So this is a statement where somebody says, I think I can be fair and impartial, and then upon further inquiry asks, but would you side with the police? You have this history, your dad's a police officer, all this stuff. He says, yeah, I might side with the police.
Well,
Did he say he would follow the instructions?
He was never questioned about whether he would specifically follow,
Well,
but he is asked whether he will be fair and impartial. That's part of the
he
inquiry.
was, actually, he was asked, as I look at it, I'm looking at pages 43 and 44 of transcripts, what's called 7, although it's called something else in our docket for some reason. I will instruct you, this is the question, I will instruct the jury seated that it must not believe a police officer any more or any less than any other witness, simply because that person is a police officer. That you have to assess the credibility of a witness who happens to be a police officer, just like any other witness that's testifying at trial. So with that in mind, let me ask you again, and I appreciate you, flagging the issue based on your dad being a police officer, but with that in mind, would you have any difficulty following my instruction? And the answer is probably not. No. And also, it's only a question about belief. And the way I understand the sided with language is he's saying, even if I don't believe the police officer, having just said I would follow your instruction not to believe the police officer, I might side with them.
Yes, and to me that says I am biased in my vote on the jury. I want them to succeed. I want them to be successful. I'm on their side. Whether they're liars or not, whether I think they're liars, I am on their side. And that's where bias is different than just credibility determinations.
if there had been further inquiry about how those two statements could be reconciled, I wouldn't believe more, but I would side with. Is it impossible that this juror would have been rehabilitated?
I mean, any juror can be rehabilitated if rehabilitation simply means getting the juror to say, I will be fair and impartial, right? But whether a juror who says, after all of this, sitting through the initial instructions on presumption of innocence, sitting through the importance of fairness and impartiality, is willing to say, I'll side with the police.
You're saying after all of this, but the question is, why did it stop there? The juror said two things that were kind of contradictory, particularly in response to defense counsel's last question, and defense counsel didn't take it further.
By all this,
That's what I'm trying to get at, whether this was an abuse of discretion by the judge, or this was just, well, defense counsel didn't try to reconcile. The juror had said, I'm not going to believe them more, even if I side with them more, and is that an abuse of discretion?
He didn't say even if. He said, I might not, but I would side with them. So,
Even if you didn't believe them more, you might side with them, is
yes.
the question. And he says, yes,
Right.
yes.
So it's, he
And,
might,
and I don't really see a contradiction here. He's asked if he would follow the instruction to believe. I don't think he's asked, are you fair and impartial after all of this?
no, he's not asked that in this context. When I said after all this, I mean the jury, and the court is familiar with, and it's part of the general, the jury watches the video about the importance of juror service.
Yeah, but,
and the role- yeah.
here in the voir dire, he's not asked after all of this.
No.
Okay.
He just says, I would side with the police. And to me, that's very clearly, I'm not fair and impartial. I would side with the police. So I don't need to do follow-up. The follow-up is then, are you sure, really? Side with the police?
Well, I would think the Commonwealth would be responsible for any follow-up, not the defendant, and they could have asked additional questions and didn't.
They could have, the judge could have, anyone could have. Once I determined that he had said he will side with the police, or once trial counsel, it happened to be, determined that trial counsel is certainly within their rights to say, I ask that he be excused for cause, and not continue to inquire about all of, I don't know, his reasons for how he became not fair and impartial. I do want to address your inquiry about what might have happened. And again, we don't know. It's hard for me to imagine a situation where somebody in this context at that moment who says, I might side with the police, can be rehabilitated in a way that is not pro forma, that really indicates that they are not biased. But, I mean, I suppose if someone had tried, you would know what would happen, but there was no inquiry. So what happened was someone who said, essentially, I'm biased, was then just seated.
So there may not be an obligation for trial counsel to do further inquiry of that juror, but is there an obligation to ask for more peremptory challenges or to, again, object and say you're not content with the jury? I mean, on those two issues, what factor do they play in the analysis?
None, because this is a structural error issue. Bias is structural error. And the cases that require an exhaustion of peremptory challenge are procedural errors, right? So if this were the issue of, I thought he might be biased, he had said some things that were ambiguous, and I wanted the opportunity to inquire further and was denied, that would be a situation where exhaustion of peremptory challenges, stating not content, all of that would be required in order to preserve. But in the case of somebody who just says essentially, hi, I'm biased, and then gets seated, that's not required because it's structural error. And that's a really important distinction, the actual or imputed bias cases versus just some procedural error in voir dire. And that distinction matters for the next issue, which if the court finds that this was appropriate and that this was not structural error, we then move on to the next issue, which is the denial of the question of whether the jurors would tend to believe a witness reporting domestic violence, right? And there we get into a really interesting question to me, which is how you prove prejudice and whether prejudice can be proven through other means than exhausting peremptory challenges and requesting another. Because in this case, the defense is arguing that prejudice was proven essentially by what wound up being a sociology experiment, although accidentally, which was you have the same population, essentially, a random sample drawn from the same population at contemporaneous times, excuse me, and the question is applied to the first group and reveals bias.
I mean, you make an interesting statistical case, but what I didn't see in your brief was an effort to explain what was wrong with the question that the judge allowed to be asked at the second impanelment. That is, would you believe a witness more because she's alleging domestic violence? Why doesn't that suffice to get at the issue of bias?
That's addressed in the reply brief. And it's the issue there, and I can get you the page number in a second, but I just want to answer the question orally first, is that there are two different issues. One is application of the presumption of innocence. Defense counsel wants to inquire about the presumption of innocence. And the court says, you can...
But the question that you wanted to ask doesn't say anything about the presumption of innocence. It says, do you think it's important to believe women who report domestic violence? That's asking jurors to commit to an abstract position, having nothing to do necessarily with court proceedings. And if you want to ask, can you go into this with the presumption of innocence, that's fine. I mean, I think the judge already asked that. But I don't see how the question that you were allowed to ask is substantively that different in terms of the issues it's trying to get at. I mean, maybe the follow-up questions are different, but that's because the initial question that you want to ask asks them to commit to this kind of abstract ideal, and then says, aha, but how do you reconcile that with the presumption of innocence? And then someone's got to be pretty quick on their feet to come up with an answer. That's my concern.
I hear the concern. To me, the question, do you tend to believe people who, and report domestic violence is make an allegation of a crime? And if they tend to believe those people, that interferes with the presumption of innocence.
It doesn't, the question wasn't, do you tend to believe those people? It's, do you think it's important to believe women who support? No, there's a difference. Do you tend to believe, asks the witness about their own approach to crediting or not crediting these witnesses. Do you think it's important, again, it's an abstract proposition that, you know, viewed in the worst light, lures jurors into committing themselves to, sure, who wouldn't believe it's important to believe women who report domestic violence? And then says, okay, well then how do you reconcile that with the presumption of innocence? And when they can't do the mental gymnastics to explain, then they're biased.
Or maybe they can't do the mental gymnastics because they think it's important to believe people, or I think, is the question women, who allege this. I mean, and there's also, although to Justice Sachs's point, there is a kind of, although maybe it isn't, I was going to say there's a kind of vernacular way in which people say it's important to believe. And I mean, I don't know, this is like an empirical question. Do they mean to believe or to listen to? But maybe they mean to presume that it's correct.
Believe is one of the definitions of presume. It's the dictionary. Presume is believe without proof or without evidence. But the question actually emerged from the contemporaneous political movement, or call it a judicial reform movement, on believe women, right? And believe women was the idea that...
Is this a question that's been used before? This isn't just something you came up with to ask? This is a formulation that, you know, that someone has suggested more broadly ought to be used in cases like this?
I don't have anything in the record. This is now outside the record. I didn't come up with it on my own. This is one of the questions that you want to inquire as to whether people are part of a movement, essentially, that says that, you know, women should be
Have you ever
believed.
done a case where a judge allowed this question? I mean, I know maybe your practice doesn't.
No, it does. It does a lot. I'm just trying. I'm worried that I'll misrepresent
okay,
exactly the
and
question.
it doesn't matter. It's outside the record anyway. I'm just wondering about the question because I'm not sure what it means, but it's a really interesting question, it seems to me. So.
And what ended up happening, of course, was that it did reveal a great deal of difficulty people have with the presumption. I can talk about that a little more if
Your time's expired. I think we understand your arguments, though. Thank you very much.
Thank you, Justices.
And we will hear next from Attorney Jansen.
Good morning, may it please the court. Catherine Jansen on behalf of the Commonwealth. I think I'll start with the for-cause challenge issue, if the court doesn't have any problem with that. I want to first start with what the appropriate standard of review is, with full candor to the court. I did find it kind of confusing and difficult whether this is structural error under Gonzalez, which I appreciate my sister citing in her reply brief, or it falls under Nelson. I feel like, you know, under Nelson, it's very similar to this case. I think it's very similar in the fact that there the defendant was challenging the fact that his for-cause challenge was not allowed, and then the court went through, and similar about police intending to side with the police 51% to 49%, and then the court went through, well, when is there prejudice when the for-cause challenge is not allowed? And basically the court said, reversal may be warranted if the judge refuses to excuse a juror for cause who should have been, and as a result exhausts all peremptories and is forced to accept the juror who otherwise would have been properly challenged. And so under that framework, I think that is the appropriate framework, but, and I think this case falls into that, where here.
But do you agree that if we found it was clear error to conclude this person wasn't biased, that is, that any reasonable jurist would look at what was said here and conclude, oh, that's bias, that then we wouldn't need to show prejudice because we would be doing what opposing counsel says, which is assessing a case in which a biased juror actually sat?
Your Honor, to be frank, I am unsure of the answer. Like I said, I found this very difficult. Maybe I shouldn't have, but I did. I'm wondering if, like any other structural error, it can be waived, and where and where the waiver occurs.
Well, structural errors can't be waived.
Structural errors, I believe, can be waived. There's excuse me.
Well, in Cohen number 1, that set of cases about closed courtrooms, I think we said that on post-verdict challenges, motions for new trial and so on, they can be waived, but I'm not sure how you waive a structural error.
I'm not sure if Jackson, which is 471 Mass 262, is a closed courtroom case. That's kind of where it goes through what is structural errors, like a list
What is
of.
the site?
I'm sorry, it is 471 Mass 262. It's not cited in my brief because I started to grapple with this in preparation for argument, so I apologize to the court. And again, I'm not sure if that is a closed courtroom case and if that's distinguishable, but I think if you're saying that this person is, say for assumption, which I'm not conceding, that the for-cause challenge should have been allowed, if you're saying that this person is, and I understand having trouble reconciling the saying that somebody's biased on the jury, then that's just bias and that's a problem. But are they really truly that biased where you have available peremptory challenges and you use one on somebody who you didn't even challenge, and you don't use it on this person, they're available, and then you don't ask for extra peremptories?
There seems to be two challenges. The one challenge in this sort of context is I was forced to have a jury, I, the defendant, that I didn't want because I exhausted peremptory challenges, and either the one I wanted to challenge was seated, or I challenged the one I wanted to challenge, someone else I didn't want was seated. But there's a different category, again, and I think that Commonwealth v. Long, have you read Commonwealth v. Long? The potential juror, actually a seated juror, indicated he had prejudice against, I believe it's Cambodian, people of Cambodian nationality. And the judge did a colloquy and found he could be fair and impartial. And the SJC reversed in finding that the judge made an error in that determination, and that error meant structural error. I don't know if they use the word structural, but my interpretation of that decision is.
Or say prejudice? Or?
Yes, and they didn't do any evaluation of, well, the defendant could have used a peremptory, or could have asked for another peremptory, or he said he was content with the jury or didn't. It was biased juror, seated, new trial, essentially.
If that's Long, I feel like I have read Long at some point, not in preparation of this argument, so I can't say for sure, and if that's what the case law says, then this is structural error, and if the for-cause challenge should have been allowed because they're biased, but then that's what the law is. I do find it confusing in relation to case law like we have like Nelson, where presumably the same issues, that juror was biased. I mean, at the end of the day in Nelson, the court went on to find that the for-cause challenge was the judge did not abuse their discretion, but doing that analysis, I feel like this case law is confusing and inconsistent in that respect on what to do, and perhaps some clarification would be helpful.
So maybe we can go back to the question of the bias.
Yes.
So I heard an interesting point in the first part of the argument. There's not necessarily a contradiction between believing whether you would evaluate police credibility the same way you evaluate other witness credibility, and whether you would side with the police. I mean, it almost suggests that even though you'd evaluate their credibility same as other witnesses, and you might not end up believing them, you'd still side with them.
I understand.
And so,
it's a
where the
nuance.
last word is, yeah, I would side, why, how could that juror be said to be unbiased?
I would suggest, based on the voir dire that occurred and the judge who was there watching this juror, watching this interaction with defense attorney, who's in the best position to make this determination. I know my sister does not agree with my reading of the cold transcript on this, but I think the judge, when she's issuing her decision on her findings on the for-cause challenge, saying he was talking about his history, his growing up, that when he was growing up, I would tend to side with the police officers just because of my experience. My dad is a BPD officer, and that question was relating back to his prior experience. And I think that's how the judge took it, and I think the judge is the arbitrator of credibility in terms of how this juror is answering the questions and how the juror is understanding them.
But the juror said, even if I believed them, I didn't believe them, I still might side with them. How is you just described what that judge thought it meant, but can you do that again? Because I don't see how it could mean anything but they would side with them.
I think because just immediately before the question, the juror was talking about his childhood in terms of, it's on page 45, and so I just wanted the defense.
Do you think it's just talking about the past?
I think because it was relating back to, in the context, he's relating back to the past and his experience with police officers. I don't think he was talking about his experience now that he would just, I would maybe not believe them, but I'm just going to side with them anyway, especially in light of the context of, I think he understands he's being questioned about bias in favor of the police and the credibility the credibility question before, I think.
So you think the judge concluded, oh, maybe he sided with police when he was younger, but that's all in the past?
Correct. And do I think it would have absolutely been better for the judge to inquire further, whether asked to or not by the defense attorney? Yes, but then I think this is like Nelson in the respect that they had said that they are going to be able to follow the law, that they will not give the police officer undue weight compared to another witness, and that it's clear they're looking, the court and everybody's inquiring about police bias and if you're going to be in favor of them. And this is directly, this comment I would tend to side with them was based directly to his childhood as a police growing up.
I guess the concern, Counselor, and we understand there's a lot of pressure getting a jury seat, There'd been a mistrial, I believe, or there weren't enough jurors.
Correct, they couldn't seat the jury.
Commissioner hadn't sent enough jurors in this case. So there's pressure to seat a jury, but obviously the defendant can't be on the short end of that pressure. And I say that because the judge has an obligation to do a thorough obligation with jurors when they are perhaps impartial. And even when she questions him about the police credibility, the answer is probably not, no. But then the next question is, do you have any concerns about that in light of the way I've told you what the instructions would be? And he says, yeah. But then the judge just moves on. She doesn't say, well, tell me, sir, what are your concerns? Let's address those.
I noticed that the transcript says sick, which I think suggests that he's just saying, I don't think he actually meant yeah. I think it might be, he's misspeaking in terms of not saying like, yes, I have a problem with that, like, yeah, like no problem, kind of. And again, this is why it's hard to do this on a cold record because we don't totally know how things are coming out, just like how probably not.
That's pretty creative. I mean, the question, do you have any concerns about that in light of the way what I've told you the instruction would be, yeah. But you're suggesting we can interpret that yeah, he's agreeing, or I'm sorry, I'm not following.
I just think, I think a lot of times colloquially people are like, yeah, no. And I'm saying yeah, no, kind of.
No one at the time said, yeah, you have concerns? I mean, judge, defense counsel, anyone.
Right. I think the way he answered is probably like, as in like, yeah, no, he might have shaken his head. No, this is why, again, we give great deference to the trial judge who's there, looking at their demeanor, assessing their answers and credibility.
Wait, you want us to presume that the word yeah means no? How can we do that? I mean, you could have corrected the record or something, but how can we say yeah means no? Because of sick? I mean, sick is bizarre also because it's sick, so unoriginal. There is no original except he said something verbally and the person wrote it down, I would think.
Understood, Your Honor. The fact that it says sick suggests that probably the tone and manner in which he said it. Again, the judge is there. No party objected to that asked a further question on that.
The defendant moved to strike the person for cause after the end of all of this.
But not based on that, specifically. And he could have raised that. I understand the court's concerns, but
I would challenge for cause about being biased in favor of police. That would be part of being biased in favor of police too, right?
I think it's also based on that last answer that came out on attorney-conducted voir dire was the basis.
I mean, the problem I have with this, I just feel like we're fishing around for ways to like make this okay. if I were a defendant and a juror was sitting who had said, I might favor police, or I'm worried that my belief in police might affect me on that instruction, or, whatever, I'd blow a fuse. I'd be apoplectic, And maybe we can come up with some reason this is okay, but then we're presuming that the judge thought X or Y. The judge didn't say any of that.
Again, the case law is we give great deference to the judge who's there, watching and assessing the demeanor and credibility, answering the questions. The judge was there when he answered that question from attorney conducted voir dire and how he could find that's how he took it. I understand the court's concerns, but this is the Commonwealth's position.
No, I understand, and you're arguing it very well. I just, I see it's obviously, like most transcripts, kind of imperfect.
Yes.
All right.
Do you want to talk about the
question?
Is it important to believe?
Sure, Your Honor. I believe that the judge was well within her discretion to preclude that question as to form, not as to substance. I think the alternate question of, do you believe it's important? I'm sorry. I just want to make sure I get the alternate question. Would you believe a witness more because she's alleging domestic violence? I think gets to the same heart of the matters. Are you predetermined or predisposed to have a bias in favor of somebody who's an alleged victim of domestic violence? And then based on that answer, follow up. In fact,
but you think it's the same? You think those two questions are materially the same?
I think that substance-wise, it gets to the same, the major heart of the issue, which is...
Why do you think half the people the first time when it was framed as important to said yes, and nobody said yes to the reframed
I think it's confusing. I think as a society, like my sister noted, we were in the middle of an ongoing movement of Believe Woman, and nobody wants to be pegged as somebody who's not
I hope we're still in the middle of that movement, although there's some indication we're not. But mightn't that movement be highly problematic for jurors sitting on these cases?
And I think that this gets to the same issue is, do you think it's important to believe woman versus would you tend to, or would you be, I want to make sure I'm getting the word, would you believe woman more or less because she's alleging domestic violence? It's the same.
Does it say women in the reframed question?
A witness. It's a witness.
So it's a witness because she's alleging domestic violence.
Yes. So it's.
So would it
Okay.
be okay to ask potential jurors, do you support the Me Too movement?
I think so. I don't think that acts for a predetermination based on the evidence. I think that goes to something that you might want to be able to explore more.
For purposes of a for-cause challenge?
Yes.
That if the answers were some way or other, it might reveal that there was cause for eliminating the juror.
Correct. And I just want to note that the judge, again, has, I see my time is waning down, so I'll just try to finish this quickly, that the judge has great discretion in terms of questions in the form in which they're asked, and I think you get to the heart of the substance. It's the same in this, and it's clear, I think, based on, when you look at the April voir dire, there is a lot of juror confusion, and then when they probed further on it, almost all of them except one, I believe, juror 20, was said that they could fairly evaluate the evidence and look at the case, that it was confusing for them. As Your Honor, Justice Sachs noted, it's kind of asked them to do some mental gymnastics, and it's a confusing question. I'm happy to answer any other questions the panel may have.
I see none. Thank you both very much for your arguments. Very helpful to us.
Thank you.
And the case is submitted. So the next two cases are paired cases involving the very same ruling. And the Commonwealth is represented by the same attorney in each, although, of course, there are separate counsel for each of the defendants. My inclination would be to, merge the two arguments together instead of doing, 15 minutes aside twice. But the defendants are entitled to each to 15 minutes, so I don't want to, you know what I mean? I don't want to sort of undermine anything that you all want to do, but what would you think about doing maybe 20 minutes aside, and you can each have 10 minutes or divide it however you want, and then, does that sound?
Yes, Your Honor, thank you.
I don't want you to feel pressure to do that.
That sounds fine, Your Honor.
Okay, so why don't we do that? So we'll set the clock for each of you for 10 minutes each, and we will hear from the Commonwealth if they have this much to say for 20 minutes.
Justice Rubin, do you know which defendant you want to hear from first, or does it matter?
Which do you guys want me to hear from first? I mean, they're called in order, right? So, in fact, the number 3 case is Rivera, which is Attorney Levchuk.
Yes.
You want to do it that way?
Well, I'll go first then.
Okay, unless that's a,
That's fine with me.
okay, very good.
Rock, paper, scissors?
Which reminds me of an interesting story I'm not going to share. But we will hear, so these cases are number 25-365, Commonwealth versus Rivera, and number 25-364, Commonwealth versus RIOS-COLON. And we will hear first from Attorney Lynch.
Thank you, Your Honors. May it please the Court, Travis Lynch for the Commonwealth. I don't think I'll need 20 minutes, but the motion judge in this case erred in allowing both of the defendants' motions to suppress the fruit of the warranted search of the apartment. The judge conceived of the issue, or the search warrant, as having 2 problems. One, seemingly, there's no basis of knowledge on the part of the CRI to believe that there was evidence of a crime inside of the target address. And the judge seems to believe that the CRI or the CI actually has to physically go inside of the apartment. We know from our Nexus case law that that just is not how this works, because you don't actually have to have anyone go inside of the apartment and see evidence of a crime in there. This is one of the drug delivery cases which we seem to see all the time.
Well, if this were, so I don't really read your opposing counsel to be defending the reasoning of the trial court. I really, although I think they probably do, I think they're really saying there's not probable cause with respect to it being the 3rd floor apartment. There's not probable cause with respect to it being cocaine, and therefore this is invalid. So maybe if you could move to those questions.
Sure. The other issues that they raise in their red briefs about the cocaine. So it's true that the specifically described controlled buys, they don't say what type of drugs are specifically dealt during those 3 buys. I would say that that's the type of hypercritical analysis that we're not supposed to engage in these search warrant affidavits. The affidavit.
How can it be, well, it doesn't seem too hyper-technical at all,
well,
right?
let me just say why, because at the beginning, the CRI, per the affidavit, is a...
She's a cocaine trafficker.
Right, exactly. That's my point.
A cocaine user and/or distributor.
Right.
And so are we supposed to assume that narcotics in this context means cocaine?
Well, I wouldn't.
When the CI comes back from each, or the trooper says in all 3 instances, narcotics were purchased in the controlled buy.
Well, I don't think it's an assumption. I think it's a fair inference, given that the specific, it's not like us CI said that. We're using the same CI who told us that information. So, and again, that CI...
It almost seems like, I'm just giving you my gut reaction, it almost seems like the affiant went out of his way to avoid saying what was purchased in the controlled buy.
Well, that's true.
I don't see why that would be important here. I mean, it's not like shielding the identity of the CI.
Well...
that I could see, to say narcotics rather than cocaine.
Well, the police are allowed to withhold information.
Sure, if there's a reason, yeah,
Right,
but there's no reason proffered here. I mean, there are other things that are, the trooper says, I'm not putting in the affidavit because it would reveal the CI's identity, but this is not one of them.
Well, I respectfully disagree with that, because the fact that you'd be able to track Rivera would be able to figure out, well, I dealt cocaine to someone, and, well,
If there's reason to believe that Rivera is also dealing anything else, which isn't listed in the affidavit.
I would still say that under the circumstances, given that It's specific that this CI is a cocaine user. Rivera is a cocaine seller.
No, that is not shown, right? That's the question. Is Rivera a cocaine seller? Right? We have a CI who says that,
what weight
but
do we
that's not
give-
probable cause, right? Just the CI. It's got to be confirmed somehow, right? Before you can arrest someone, you can't just take a CI's word and go and arrest.
I mean, the CI clearly said she's a cocaine trafficker, major cocaine trafficker in Hampden County.
Yes.
How does Aguilar Spinelli support that? I mean, maybe the CI, has established credibility in other ways, like being able to arrange 3 controlled buys.
Right.
But what about basis of knowledge? We don't know if the CI ever bought cocaine from her or saw her in possession of cocaine or any of that.
Our position still is that it's reasonable to infer that where the police are saying the CI is a cocaine user, and the CI tells us, outside of the controlled buys, the CI tells us Rivera is a cocaine dealer, and then when you do 3 controlled buys between a cocaine user and someone who the cocaine user says is a cocaine seller, it's reasonable to infer.
So you haven't hidden anything from the defendant?
Well, I mean,
If this means probable cause that they're selling cocaine, if that's what this affidavit means, and you're saying that is what it means, then now the dealer knows, alleged dealer knows, oh, it's someone I sold cocaine to. I mean, do you see what I mean? Like, so what's the point of not saying cocaine, if that's what you mean?
well, if it doesn't have any effect, then it doesn't really matter that they didn't say what was specifically purchased. I understand what you're saying.
Yeah, but they're supposed to say, I mean, right, we've said a bunch of things, right, that that you have to identify the drug. You can't just say drugs.
If we're talking about the particularity cases, I read those as being about the face of the warrant, not about the contents of the search warrant affidavit.
Well, the face of the warrant has to be supported.
Well,
Right.
yes, but there's still a cocaine dealer, a cocaine trafficker, who's selling to someone who says they're a cocaine user. I think it's reasonable to infer that. I don't want to keep repeating myself.
No, but that's your argument, is the inference from the, okay. Can I ask you about this? In fact, the warrant doesn't just say cocaine. It says, see Addendum A, which is incorporated herein by reference. And Addendum A says, what is authorized is search for, quote, cocaine, a Class B substance, which may be present, and/or any controlled substances which may be present, or which has been manufactured, delivered, distributed, dispensed, acquired, or held in violation of Chapter 94C of the Massachusetts General Laws. Why doesn't that defeat particularity, since it seems to say cocaine and/or any other controlled substance?
Well, I think there is a specific controlled substance in there. And then there's other things in the search warrant as well. Now we're getting into, I mean, we're partly hampered here because the motion to suppress was not to the face of the warrant below. This was not litigated as a particularity problem below. And if there's a problem with the particularity of the face of the warrant, then there's other things that could be litigated about that. But that's not how this was done below. It was a 4 corners below.
I'm talking about the 4 corners.
No, well,
Addendum A is incorporated here, and it's within the 4 corners, right?
right, but a particularity issue is different from whether there's probable cause. Because you have to name the particular place to be seized, the particular place to be searched, which is there.
Or the particular item to be seized.
Right.
That's what we're talking about here, the particular
Right.
item to be seized, although it might be that some drugs could be hidden somewhere where another kind of drug couldn't be hidden because it's too big or too, I don't know.
Okay, but the warrant does identify a specific controlled substance, and then it names other things like paraphernalia, scales, packaging materials, cutting agents.
Any other controlled substance.
Yes, but I don't think that the fact that they included that in there defeats the warrant.
Is there any reason to, from the affidavit, to believe the police actually knew what controlled substance the CI had purchased in the 3 buys?
I don't think there's anything in there that says that they did field testing or anything like that, if that's what you mean, but,
Yeah, or anything.
They gave him a certain amount of money.
right.
And the amount of money you need to buy cocaine is different from the amount of money you need to buy heroin, is different from the amount of money you need to buy fentanyl, is different, right? So presumably they know what he's going to buy.
Yes, also they also listened to the CI set up the deal that's in there too. I mean, they don't say what
What the deal is. But
right, right. So.
Can we talk about the 3rd floor?
Sure. So I would say that we have, I mean, again, this is not how this was litigated below, but Rivera seems to use a separate door to get to this other apartment that's inside of this.
Well, no, she uses a separate door.
Right, right. Well.
And it's true, that door does go to the 3rd floor and
Right.
the 2nd floor and the 1st floor.
Well,
So to some extent, she's using what I'm going to call the back door.
Well, there was also investigation by the investigators to the effect that she has no interaction with the other people who live in the.
There's no indication there's anyone home at any of these times. I don't know. Where would you see these? I mean, it's not spelled out. It does say that, but I don't know what that.
The search warrant on its face authorizes the search of 4446 3rd floor.
Yes.
Yes.
And it even says that Cologne Rios resides there.
Yes.
Well, the affidavit does, right?
Yes, I believe so.
Okay, but it doesn't say because we saw Cologne Rios's driver's license, or because we checked utility bills and they're mailed to Cologne Rios there, or because, right, it doesn't tell us anything about how, I mean, ordinarily I would expect to see, and there are utility bills, or and someone told us they live on the 3rd floor, but this is an entrance to a apparent multi-dwelling unit. No one says the lights go on the 3rd floor when she goes in, although maybe that's because it's daytime and the lights don't go. You know what I mean? I don't know. But there's just nothing linking except this doorway, and the doorway does have a doorbell to the 3rd floor, but she doesn't ring the doorbell. I don't think.
I understand what you're saying about that issue.
Mm-hmm.
So on 44, observations were made by investigators indicating that the 3rd floor of the residence was being utilized as an additional apartment. So again, I don't think it's not like it's not like it's an enormous.
It's
apartment.
It's apparently a 3-unit building, right?
Yes, I understand what you're saying.
Yeah.
But at the same time, I would still say that she doesn't interact with the other people who live in this building, which suggests that they know that there's other people who live in those other apartments, so.
Or living in the building.
It seems as though that 3rd floor apartment is separate from the other 2 apartments.
It seems like it's an illegal apartment, I think, right?
That's what I thought too.
Right, because somewhere it says it's a 2-unit house.
Right.
And then it's being used as a 3rd floor
Right, well,
apartment. And it sounds like you can get to it from the 2nd floor.
Yes.
But also it has a direct entrance in the back.
I don't
Or on
really-
the side, wherever this entrance is. But
Yes.
the front doors go to apparently to the 1st and 2nd floors.
I understand what you're saying, but I don't really understand. I mean,
Well, we
Sounds
have.
like
the-
it's a separate apartment. It sounds
Okay,
like that.
so then it's an apartment building with 3 apartments.
Right.
But we have cases about that. You have to know which apartment, don't you?
I think the fact that there's that back entrance still supports that.
Probable cause.
Well, that's not that high a standard. I understand.
Okay, you can start
it is a
talking that
standard.
way, but it isn't reasonable suspicion. I mean, maybe there's reasonable suspicion. Why is she going in the 3rd floor? That's the one with the doorbell. I suspect that maybe she's going up to the 3rd floor, not going into the 1st or 2nd from there, although I'm sure we all know people who always go in the back door of their house. I certainly know people like that. There is a front door. They can go in it. But whatever, they go, right, they park in the garage and then walk in the back door. You know, only delivery people ever use the front. I mean, there's lots of cases like that. Maybe they all go in the back door. I don't know.
Right, but they also say that Rivera doesn't interact with the other people who live in this house.
They also don't say there are any other people living in the house or there when she's there.
Okay, but this is,
It's probable cause. I mean, this is surprising to me because usually we see something pretty good tying the person to the apartment. And it doesn't necessarily have to be that someone was in the apartment and saw it. People have stash houses where no buyer ever goes in and so forth, you know, but there's a utility bill or something.
just because they could have presented more evidence doesn't defeat what was actually presented. I
No,
understand
I
what
agree.
you're
Oh, of
saying.
course I agree with that, of course. But it just depends if there's probable cause or not. That's what we have to sort out.
I understand. Unless there's, I mean,
Yeah,
do you have any
sure.
more questions? I have even more
I think we
time.
can find more. Yeah.
Well, I'd like to go back to the, whether there's probable cause to think there was cocaine there. I mean, we have controlled buys. We don't know what they were. You know, the CI says she's a cocaine trafficker. The CI's credibility may have been established by the fact of the controlled buys and, you know, the trooper knows who the CI is and so forth. But what
Yes.
about what about the basis of knowledge? What is the CI's basis for saying that the defendant is a cocaine trafficker?
Well, I see what you're saying, but I don't have anything else other than what's in there. And I think I don't have another answer to your question than what I said
Well, let me
before.
put it this way. Do you know of any cases that say this kind of statement by a CI in an affidavit can be accepted or can be relied upon for probable cause purposes?
As basis of knowledge? No, I can't think of one where that specific, I mean, if you're just saying this statement in isolation, I can't say. I don't know. Unless there's anything else.
I would just say it's important for the affiant, for counsel to be very precise with their wording. And I just wanted to raise an issue that I think it's page 47 in the appendix, the affiant describes the CI as having been involved in, well, actually, let me read it instead of trying to read it from memory. So at RA 47, these investigations ultimately led to large seizures of narcotics and/or firearms and the arrest of defendants. So we have and/or firearms, the disjunctive, excuse me. But in your brief, you say the investigations have led to seizures of narcotics and firearms and arrests. And to me, that's not insignificant, so I just wanted to, I don't think this decision is going to turn on that, but I would just encourage you to be really careful and precise as you can with language.
I mean, it's a long affidavit and detailed, but just to take Judge Smith's point, it's just, I'm not saying that there may be no reason why these things were left out except just, you know what I mean, sort of failure to fine-tooth comb it before submitting it. And let me also say, I feel like we've been beating up on you a bunch. You're doing an excellent job. You have what you have here, and we're questioning you about it, but you didn't write the affidavit, you know what I mean? So
You mean in the affidavit?
Well,
You mean in
we
the
do,
brief?
yeah, we've been questioning you about, is there support for this and is there support for that? And you're doing a perfectly good job of defending it.
Thank you.
Let me ask you this. So on that page 47, about the CI, the affidavit says, the CI has conducted controlled purchases of narcotics during this investigation, which corroborates the information the CI provided at the beginning of the investigation. The information provided at the beginning of the investigation was essentially the defendant's a cocaine trafficker.
Yes.
So can we make anything of that?
I mean, I guess that
Does an inference arise from that?
I guess you
And
could.
I'm asking this because I want the defendants to address it too. Does an inference arise from that, that the controlled purchases corroborated the CI's allegation that she's a cocaine trafficker?
I suppose you could say that because, I mean, yes, I suppose you could say that.
I guess I'd just also say for the future, because presumably prosecutors work with police on issues like this, if the court has to be able to find what the drug is, right? So now we're figuring out whether inferentially it's cocaine. It's just sort of the corollary of what I said before. Then nothing is really being hidden from the defendant in not mentioning what the drug is. I mean, an affidavit ought to say what the drug, I mean, maybe it could just say at least one of these buys, or, I don't know. Obviously I don't know the facts on the ground.
Right.
But it's very tough for a court to approve something if it doesn't say what it is you're searching for. I mean, particularly, we've got this case now, Padilla, right, which says just saying any controlled substance isn't good enough, so.
I mean, I know that I'm over time. Can I just
Well, yeah, go ahead,
So,
sure.
I mean, again, it does specifically say cocaine, and there are other things in the there's other things in the warrant
Yeah.
besides just controlled substances. I think in Padilla, they didn't name any drugs. That's my recollection of that case, but.
Well, they did say any controlled substance
Right.
that is manufactured, distributed, it's the exact language, actually.
Right, but I don't think that they had something like cocaine.
No, I agree, but I'm saying the affidavit ought to support what the judge has to write. The judge has to write the name of a drug on the warrant, if that's what they're searching for.
Understood.
Okay.
Thank you very much.
Thank you very much. We will hear next from, of course, I have too many pieces of paper here now. We will hear next from Attorney Levchuk.
Thank you, Justice Rubin, and may it please the court. I think there is a theme running through the set of arguments the court has heard this morning. The previous argument was the yes means no argument. We can call it that. This is the narcotics means cocaine argument. As Padilla held, there is simply no basis for this court to have to assume something so basic to probable cause as to what drug we're searching for.
Well, what if the police don't know what it is? I mean, in Padilla, I think they did know. That's what the decision says. And here I don't see any indication that they knew. Now, maybe they could have easily field tested whatever that was the controlled buys and found that it was cocaine or something else, but
Well, they could have done that.
yeah, but we don't know. But we don't know if they knew.
Well, we don't know anything, and I guess my point is, to establish probable cause, we have to have probable cause to believe that the substance that was involved in the 3 hand-to-hand transactions was cocaine, and we just don't know that. It's put in there as narcotics, and even in that final paragraph that you, Justice Sachs, just drew attention to, and I'll find it here in a second, it states, again, narcotics. It would have
But
been...
that does suggest that they know that it's not sugar,
Well, they have,
right? So they are asserting in the affidavit, or the officers asserting in the affidavit, that he knew that it was narcotics that were delivered, not some white powder.
Actually-
Now, it doesn't say what the narcotic is, but it also doesn't say, and he delivered to us a packet of white powder.
Actually, that would be just as good as what he did say. For all we know, it was white powder. That's what's wrong with this affidavit. I mean, we just don't know what was delivered.
Well, I thought we don't know which drug was delivered. I thought we knew it was a drug because I thought he said that he came back and was found with narcotics on
With
him.
narcotics, but there's no basis. How do we know that? How do we know it's not a flower?
He's saying, the trooper is saying it under the penalties of perjury, so,
Well,
yeah, he doesn't state the basis, but
right, but, and that gets us back to Padilla. I mean, it seems to me that among the most basic things when you're conducting a search of a residence for cocaine is to establish that the transactions, which are, and again, this goes to a point you made, Justice Sachs, the only basis of knowledge would be, it seems to me, that's laid out in this affidavit, the 3 controlled buys. And that would establish the basis of knowledge that cocaine was being dealt. And it's critical here, and we simply don't know. And it could easily have been field tested, easily identified, and it just wasn't done. And if you're going to go in and search somebody's residence, at a minimum, it is not too much to ask police to be able to provide this level of information to a magistrate judge.
Do you think identifying the drug might identify the CRI?
I don't know how that would, I mean, he has identified her, the defendant, my defendant, Ms. Rivera, as a known cocaine dealer. It is possible that if she was really an active cocaine dealer, she might well have, numerous customers, and it would be difficult to identify the confidential informant. And while I agree, the government can withhold information to try to protect the confidential informant, it does so to a very dramatic degree here. In other words, it's like the officer states, I know that this informant has provided accurate information in the past that has led to arrests and convictions. But you have to, again, you're taking his word for it, when in a more carefully drafted affidavit, one could be more particular about that without giving up the identity of the informant.
Oh, it is true that he doesn't say for narcotics. He says narcotics and or firearms.
And or
so
firearms.
So maybe it's all firearms.
Well, I was going to mention that. I would not have thought of it without the assistance of Justice Smyth, but it's a fair point that it, the and or in the disjunctive can mean all firearms. And I think that gets to a major problem with this affidavit, which is that as long as it is, and as detailed as it is, a lot of that detail is boilerplate. You could look at affidavits from troopers and agents assigned to the Western Massachusetts Gang Task Force, and 60%, if not 70%, of the language in this affidavit has been used dozens and dozens of times. And when you don't read it and you just, get on your word processor, you get what you got here, which is something that simply doesn't establish probable cause. I'd also like to go to the particular place to be search issue. Again, it's a multi-unit apartment building. This is not a single-family residence. There are 3 units in there. All 3 units can be accessed from that side door. And so going to the side door, she could have gone anywhere in that building. The statement that is made by the affiant that we haven't seen her interact with the people on the 2nd or 3rd floor, well, how would they see that if she goes in the side door and goes to this 1st floor or 2nd floor apartment? She easily could have gone to one of those 2 apartments. And the informant has no basis to know where she went. As far as it's laid out in the affidavit,
Well, the question is actually, do the police have any, right? The affidavit isn't from the informant.
Understood.
Right. The police could come up with that information a million different ways, maybe, or maybe it's impossible.
Right, but in other words, as you point out, Justice Rubin, when you have a multi-unit building, almost invariably in an affidavit, you will see some evidence as to why the affiant, the police officer or federal agent believes that it's one location in the building rather than another. Here, looking at the four corners of this affidavit, she could have gone anywhere in that building. She could have gone to the first floor, the second floor, the third floor, the attic, if there was one, a basement if there was one.
Well, we don't know that it opens into the attic or the basement. We know that it opens into the first and second apartments and has the first and second floor apartments and has the only direct entrance into the third floor.
Right, but it could have been to any of those three apartments, and that's not sufficient to establish with particularity the place to be seized.
Does the independent doorbell to the third floor make a difference?
It shouldn't. I don't
Doesn't
believe.
that imply, or isn't it a reasonable inference that that is the entrance that is the most likely to be used to access the third floor?
If there's a doorbell to the third floor, that is the entrance that a visitor might use to visit someone on the third floor. She's not a visitor. She goes into the building, and once she's in there, it is a black box. We have no idea where she goes. And so I would say, there's just simply insufficient particularity here.
I don't know if you know the answer to this. We have upheld some searches in multi-unit buildings. I remember in some cases, of course, they're not like this is like a house or something, a two-family house with an illegal third-floor apartment or something. I have no idea. Maybe it's legal. I don't know. But there are cases where the officers are able to go into the vestibule because it's not trespassing or someone else opened the door or something and see something going on. And there's a lot, of course, where the actual informant making the control buy goes to a particular apartment. Do we have any cases where you can't do that kind of surveillance?
No, if it's a common area, I was going to suggest, I see no reason why an undercover officer simply couldn't go up to that door and ring the bell.
In order to do what?
In order to perhaps find out who comes down and answers.
Well, they're going to destroy the evidence that's up there pretty quick.
Well, depending, if
Now, maybe you're
undercover,
supposed to
you're
not
sure.
be able to create your own exigent circumstance, but
No,
I think that would
I'm not
create...
suggesting that. I'm suggesting going in undercover, pretending you're the FedEx guy or whoever it might be. And at least, that would be so easy to ring the doorbell, see who comes down. Oh, I'm sorry, I have a package for so-and-so. No, it's not me.
Well, we're speculating. Your time has expired. Do you feel like it's adequate?
I do, thank you.
All right. Thank you very much, and we will hear finally from Attorney DiMaria.
Good morning, Your Honors. Daniel DiMaria for Leslie RIOS-COLON. Your Honors, if it may please the Court, the affidavit in this case did not establish probable cause to search the third-floor apartment. The core problem is straightforward. There's not a single piece of evidence connecting drug activity to the interior of this apartment. The informant never entered it. No officer ever observed drugs inside. The only evidence of drug activity was 3 controlled buys, all occurring at remote locations. Leaving a building before drug sale does not transform that building into a stash house.
Isn't it, we have 2 controlled buys where the defendant left Sterling Street, got in the Rogue, went to the controlled buy without stopping, did the buy, or did the sale, and then, so isn't it a reasonable inference from that the drugs were stored either in Sterling Street or in the Rogue, which was also the subject of the warrant?
I would disagree respectfully, Your Honor. So in the first buy, Rivera was observed leaving Sterling Street, driving directly to a prearranged meeting spot where the CI purchased narcotics.
In each case, doesn't Rivera stop at the house? Like, the Rivera isn't in the house already. The call is made, Rivera's car shows up at the house, Rivera goes in, comes out, and then goes directly there, right?
Not on the third one, Your Honor.
Oh, on the third one, it's returning to. But I just think, I mean, I'll tell you what I think. I think there is probable cause to believe there's drugs in that building somewhere, but I don't know that there's probable cause to believe that it's the third floor apartment. And so my question is really just about the third floor apartment. Is there any evidence recited in the affidavit that shows that this is the residence of your client?
No, Your Honor.
It asserts it, right? But it doesn't say why, how they know that.
Yes, Your Honor. The only thing that ties my client to this is the 2017 Nissan Rogue, which Rivera is using to go back and forth. But there's no RMV records.
No, but I'm saying, I think the affidavit says ultimately at some point that RIOS-COLON lives in the third floor apartment, but it doesn't say how they know that.
Yes, Your Honor.
Right? So if the person whose car the drug dealer is using lives here and the person is going here, you know, if we knew that the utility bills came to RIOS-COLON at third floor apartment, we'd have a stronger case, right?
I'm sorry, Your Honor, I didn't catch the question.
I'm just saying, obviously, not obviously, presumably, there's probable cause that Rivera knows RIOS-COLON. Rivera is driving RIOS-COLON's car.
Of course.
Okay. So if it turned out that RIOS-COLON was the resident or renter or whatever of the third floor apartment, that would tie Rivera to the third floor apartment in some way. But
Exactly.
There isn't anything like that.
Right, there is nothing like that, Your Honor. And so I would also argue that, and this has not been touched on by either counsel, that in my respectful submission, the affidavit was stale. The Massachusetts courts have held that narcotics can quickly be used. It's not like documents. Documents, you can go back and store
But if
them.
someone has been selling drugs for a long time from a location, including within 3 days of getting the warrant, and it's executed within 5 days of that, that's a little different from a one-time, you know, we don't know if there's still any drugs there kind of situation, isn't it?
I mean, all we have in terms of particular are the first one in July 2023, the second one within 21 days, and the third one within 72 hours. I would say the third one is the most tenuous of them. She's at a remote site, Rivera's. She supposedly sells narcotics and returns to this multi-unit building. And so I would respectfully submit, Your Honor, that that third one within 72 hours is so weak that when you view all three, it's simply not sufficient. No one ever saw Rivera retrieve drugs from the apartment, handle them. The police could have done a trash search. They could have done a ruse, UPS package, like I believe my co-counsel stated. They could have done all sorts of things, which they simply did not. And so I think in addition to all its infirmities in terms of it saying cocaine and controlled substances, yet the affidavit only states controlled substances, in terms of the third floor apartment and in terms of the dates and this third sale, that the affidavit falls far, far, far short from establishing probable cause. And if there are no questions, I would rest on my submissions.
Okay, thank you very much. I see no further questions. Thank you all for your arguments, which are very helpful to us. We are now going to take our traditional mid-morning break, and we will return after 10 to 15 minutes to hear the remaining cases. Good morning again.
Good morning.
We continue our sitting with an impounded case, so of course, pseudonyms and so forth. This is DOE number 25324 versus Sex Offender Registry Board, number 241104. And we will hear first from Attorney Krismer.
Good morning, Your Honors. Laura Krismer for Mr. W. I wanted to start with the argument surrounding the need for expert testimony. And I wanted to acknowledge that the SJC in two different cases in 2006 and 2011 did hold that at that time, due process was not violated by the lack of expert testimony. But what I suggested in my brief, and I suggest to this court, is that since the DOE 308316 case, which is the case that changed the standard of review to clear and convincing evidence, and I think that that case really lists for this court all of the significant and substantial changes that have undergone in the sex offender registry law since its inception back in the 90s. That expert testimony is really necessary.
Can I ask about the two cases that held this?
Yes.
I looked at one of them, and it doesn't really say due process. It says the statute doesn't authorize, and it's not necessary, and then maybe it cites a case, or cites a case that cites a case or something. Am I right about
Yeah, I
that?
think
That it
it's
doesn't square?
Yes, I think you are correct. I think one of them is a little bit circuitous, for lack of a better word.
This is the one written by Chief Justice Ireland, or maybe
Yes.
Justice Ireland at the time.
Yes, I don't disagree with you. What I made in our argument is a clear due process.
No, but I just want to know what the state of the law is.
Yes.
The other one,
So it's procedure due process.
It's procedural due process,
and
yes.
is the other one says there's no liberty interest?
Yeah, it basically says that the liberty interest of the individual, the person having to be classified, is not equal to.
So it's Matthews v. Eldridge. It's a balancing test. Okay.
And in terms of that, I think the reason why I'm directing you back to 308316 is that case really changed that the balancing test in the sense that it said, now the interests of the individual are much higher because we've changed the law. We've now got level 2s that are on the internet. The internet has exploded. I don't think.
But they took into account all those changes and said, now we need clear and convincing evidence.
Now we need
But
clear
your
and
contention is that they didn't go far enough. Because
My contention-
by ratcheting up to clear and convincing evidence, they in turn created the constitutional requirement for an expert at every case without realizing it, in essence.
Yes.
Well, I don't know if that issue was before them there.
It was not before them.
But you're not saying that that decision compels this decision. You're saying the acknowledgement of the strength of the liberty interest involved.
That's correct.
As being strong enough to require clear and convincing evidence also means we can't have non-expert SORB examiners without expert guidance determining this level.
Yes, it's basically that, essentially, since we now have clear and convincing evidence, that's the standard, the burden of proof is clear and convincing evidence. Clear and convincing evidence is a high degree of probability, and you can't have a high degree of probability in this context, is my argument, essentially, without some kind of expert testimony, because otherwise, you're kind of just going on a feeling.
Expert testimony on what, though? And one of the other changes you point to is the 2019 determination that there needs to be a third separate determination on the efficacy of internet dissemination.
Yes.
Do we need an expert on the efficacy of internet dissemination?
I would suggest that if we're going to have an expert, that the expert could speak to all three, but I think.
Could, but
Could,
what's required?
I think it's required for the risk and dangerousness, and I think a psychologist could speak to risk and dangerousness. I think the internet dissemination could be maybe subject to a hearing examiner making that decision, because once the expert testifies, assuming that they believe the expert, obviously that goes without saying, but assuming that the expert says, this person's a low risk, low dangerousness, then the hearing examiner, I suppose in some unique circumstance, might say, well, we still think that there's internet dissemination for some other reason.
Let me ask about, if I can narrow it just slightly.
Yes.
I know SORB has never found that someone is a high risk of danger but a low risk of reoffense,
Yes.
or a low risk of danger and a high risk of reoffense, but classified the person as a level 1 because of that. At least not in any case I've seen where like 2 and 3, or I've just
No.
never seen that.
Not that I'm aware of.
But the expert really is not about the danger. Isn't the danger, aren't they supposed to look at what the offense was that they committed before and assume that it's that offense they would recommit?
Well, I don't know that you assume that it's that particular offense, but yes, that goes into the factors. Like an expert would probably do, like some of the.
But that would be about risk of reoffense.
To be risk of reoffense, but also when you're contemplating in terms of the SORB statute, you're looking at the risk of reoffense, and then you're calculating dangerousness based on that risk of reoffense. So
Well, yes, but also what you're going to do. So, for example, I don't know if they've squarely held this, a non-contact offense, well, Chief Justice Gantz said, like, unless it's accompanied by an immediate threat of a contact offense or something, that isn't dangerous in the way that we mean here.
Yes.
Right, so you can have risk of reoffense be wherever it is, but it can't be dangerous.
if it's a non-contact
Yeah,
offense,
yeah.
although I think that there's some cases, and I don't know them off the top of my head, where there are non-contact offenses that nevertheless the person was given a 2 or a 3 with
Well, I
internet
remember one
dissemination.
where the person also photographed their hand on the door of the apartment of the
Right.
person,
There's-
did a
that's-
bunch of things that suggested I'm not going to be limiting myself to non-contact offenses.
Right.
So what factors is the expert needed on? Every single factor that the board finds applicable?
I think that yes, I think that all of the factors, because part of what happens, and this sort of bleeds into my second argument a little bit.
Every factor that the board finds applicable?
Well, yes, there's the list of factors, the high risk, risk elevating, and mitigating.
Right.
And I think that the expert should be able to speak to all of those
Well,
factors.
let's not talk about should be able to. Let's talk about is constitutionally required for.
I think that I would start at a platform of that they are required. I'd have to go through each, I'm sure that there's a couple of them that, I'm thinking here on my feet a little bit off the top of my head, but some of them are static factors that, like,
Age at first offense.
well,
Number
so
of
that's
victims.
one that I actually think the expert needs to speak to, which comes up in this case.
Well, we know what age the person was,
We know,
presumably.
and it's not, this is what's deceptive about the way they read the factors, right? It's not just the age at the first offense, but then it's also like what happened after that. It's also what the actual offense, as they found in this case.
But those are different factors, aren't they?
But those are, but they're elements of the same factor, and I do think that an expert, unlike all of us here, I don't think any of us are psychologists. I can't say that I know that that is going to be.
A regular
subject.
psychologist doesn't know either, right?
No, but they
This
have-
guy Jansen seems to know, and I'm sure there are other experts in this.
Yeah, they have a better ability to speak to that.
So I assume that I'm going to hear from opposing counsel, yes, this is, it was through the examining expert published articles by experts that these factors were chosen. The reason this is risk elevating is the regs, I think the regs cite them, or maybe something that accompanies the regs says, an extra-familial victim is this kind of risk, but a family victim is that kind of risk. And the articles, some of them at least, go into real percentages of likelihood of reoffense. If you're 10 years or 15, I don't remember, something out in the community, at some point they say you're the same as, although I don't know that SORB agrees with that, but the articles say you have the same background as anyone has as background risk who's committed this offense, that kind of thing. Why isn't that good enough?
Why it's not good enough is, Carl Hansen recently submitted it into a case in the SJC, that the SORB has taken some of the research and kind of manipulated it, for lack of a better word. So it's not accurate to what the actual research. So that's my first point about the research, is while they cite this, and I will say I've been doing this for over 20 years, they've done a much better job of having the research be much more accurate than it was in the 90s when we first started doing these cases. But now, it's still not accurate to the factor for a lot of them. And that's why, also why I think the psychologist or an expert is necessary on a due process, because somebody with some expertise needs to be siphoning out from the particular case, how does that factor, how does that research apply or not apply to this individual?
Can I just get clear, do you agree that there are any factors as to which an expert would not be applied? Because I gave the example of age at first offense, and you said, that's
No.
not so objective because...
And you're putting me on the spot here because I'm struggling a little bit to recall all of the
I'll give you a
factors.
couple other potential ones. Number of victims, level of contact, public place.
I would say all of those are experts, because let's talk about public place for one moment. What is a public place, and how is that defined in the research versus the SORB's regulations? How it is defined in the SORB's regulations
Well,
is
attacking the
different than...
regulation seems to be a different thing than saying expert evidence is needed to determine whether the criterion in the reg is satisfied.
Well,
I mean,
I'm just
maybe
going
you think that the SORBs or an expert could say that the reg is invalid because it is too blurry about what really...
Yes, like I'm thinking about a case I had a long time ago where the hearing examiner found that the bedroom in a home was a public place because it was shared by two people, right? And the man went in there and perped a child in that bedroom. So they said that because
Was the other person in there?
No, because the wife had access to that room, it created a public space. And that's what I'm talking about. I mean, to me, that seems kind of ridiculous, that my bedroom, because I share it with my husband, is a public place.
I could see.
But that's what I'm saying, is that's why an expert really is necessary.
All right, so what really bothers me isn't so much, although this does bother me for another reason, but isn't so much they won't be able to figure out how many victims there were, or was it a public place. They're then asked to weigh these things. That's where it seems to me a lot of the action is. We know they're not allowed to just count them,
Right.
right? And we know that they're supposed to do what's called, I don't remember what it's called, a substantive analysis.
As opposed to a cumulative one.
Or something,
Right.
no checkbox.
Qualitative.
What?
Qualitative. Yeah.
Qualitative analysis. And I always think, well, how the heck do they know how to do that?
Well, that
Why
we-
do they, I think this trumps that.
Right.
And maybe there's an actual answer to that question.
Well, and also Justice Smith might think that trumps that, right? And that's...
Oh, I understand. That's what I'm saying. The hearing examiner may say, which is, I'm saying, how does a hearing examiner know whether it's more important that they were, in the community for so many years, or that they, that their offense involved a child over a 10-year period? You know what I mean?
Right. Well, so that leads to the other, sort of a little bit to the other issue, which is that the hearing examiners, certainly they have some expertise, they're trained to some degree, but they don't have the expertise that an expert witness would have in terms of assessing all of those, this or that or this. And Justice Sachs, you authored recently in December a decision that has a great quote that I want to direct all of you to, is that we cannot effectively review whether the hearing examiner gave appropriate evidentiary weight. I like quoting to you, it's great.
Thank you.
That clearly explains if it doesn't clearly explain what the weight he gave or the results and why. And so this leads to the second argument that I have in this case, is when you say I apply something, well, how do you apply it? Do you apply it in this way, in that way? Do you weigh it heavily? Do you weigh it lightly? I mean, this case was specifically to 35, but what I would say is that what you said in that case is true for all of the factors, that if you're just saying, I apply this, that's irrelevant. Whereas a psychologist, they would tell you that how I'm weighing it, why I'm weighing it.
Relative to all the other factors.
They would balance all of the other factors.
Can I just ask two other questions about the scope of your argument? One is, would the expert, this is SORB's expert,
Yes.
that you say needs to be supplied. Would the expert have to testify about all of the mitigating factors that SORB either thinks are relevant or is rejecting the relevance of?
Yes, I think they have to talk to the I don't think any licensed psychologist would not talk to the mitigating, my understanding at least.
Okay.
They would do that.
And what about if the SORB has to have an expert, then does the offender have a right to have the offender's own expert.
I think if the offender is dissatisfied with the result, it would follow kind of the same procedure. If the offender is dissatisfied with the result, then the offender could get
But
motion
that kind of
for
has to be
funds.
known before the hearing, doesn't it?
Yes, that would, so it would
then
be
the
part of the
expert-
preliminary classification is what I would suggest.
So the expert needs to be involved in the preliminary classification?
Yes.
And then, if there's a hearing, then not only must the expert for the board testify, but the expert for the
Yes.
a defendant.
And I would suggest to you that the statute itself actually contemplates this, because 178L1A says that a sex offender can get funds when the board intends to rely on an expert. And I put in a little parentheses, which I have never seen in 20-plus years doing this. I've never seen them rely on an expert. But what I'm suggesting is that they should rely on the expert. In closing, I would ask that the court, that you issue a published decision consistent with the conclusion, and that you vacate Mr. W's Level 2 classification and remand it for a hearing.
I see
with an
further
expert.
questions from the panel, so I'm going to ask you to stay while they...
Sorry.
Stepping away from the weeds a bit. kind
Okay.
of The larger
You're
picture.
coming out of the weeds. Okay.
In the criminal context, defendants obviously have the full panoply of protection, constitutional, federal, Commonwealth. In a criminal trial, if a defendant is seeking to establish they're not guilty because they don't have criminal responsibility, they'll shift the burden to the Commonwealth, who then has to prove beyond a reasonable doubt whether they can conform their conduct, whether they can appreciate the wrongfulness, criminality of their conduct, or whether they have significant mental health impairment, just generally.
Right.
But in that context, our SJC has said very clearly that there's no expert testimony required.
You're putting me
I
on the
guess the
spot a
question
little
is
bit. I haven't done one of those cases in a while. So your
The real
question
general
is-
question is if the jurisprudence from our SJC is that the Commonwealth doesn't need an expert to prove those mental health, which can be very complicated, can be very dependent on diagnoses, symptoms, et cetera. In that context, why then would there be?
I guess I'm struggling a little bit with that supposition. Just when I did do trial-level criminal work, we would usually have somebody, a forensic psychologist, that would evaluate the person, and that person would then testify regarding criminal responsibilities. That's what you're speaking to? Because I think there is an expert in that
I think
context.
that's different. That's civil commitments. This is more just generally, but take my proposition that that the Commonwealth, to prove beyond a reasonable doubt,
That the person can
again,
comport.
does not need an expert. And I guess, so the question is, if the burden's even lower, why would an expert be required in this context?
I think it would be, in this context, it would be a little bit different in the sense that the sex offender registry has this sort of internet dissemination aspect to it, which is a little different, although criminal, obviously people could read it in the newspaper and things like that. It has a much more broad reach because of that. And so I would suggest that there is a substantial due process issue with that because the person is being penalized essentially as a result of that. Pardon my struggle on the criminal stuff.
Yeah, you have another question.
Oh, I have another
I
question.
just wanted to make
Great.
sure, I didn't see this issue of the need for expert testimony raised before the board.
It was not raised before the board. It was raised in the Superior Court. It would not be appropriate to raise it at the board level, is my suggestion to Your Honors, because the hearing examiner has no power to say.
I thought the board
yea or
had
nay.
said that they can't hear constitutional claims, that they're supposed to be raised.
In the
I
Superior
mean, we'll
Court.
ask that they're supposed to be raised in the Superior
Yes,
Court.
and on that issue, though, I would suggest that the board in their brief suggested that it needed to be an action for declaratory judgment. And I would say, no, it's not. 30A 14.7, I believe it's A, the very first one, is a due process, which is what the claim was that counsel was making in the Superior Court.
I mean, I understand that where there's a challenge to a regulation or the statute, the hearing examiner is bound by the regs, bound by
Yes.
the statute, and so cannot grant relief in that case. But here, I don't know of any reg or statute that says the board can't have an expert at the hearing. So in theory, if counsel at the hearing level had said, board, you need an expert to prove any of this, then the board could have said, oh, yeah, maybe we do, and could have gone and gotten an expert. That's within their jurisdiction. So is this the kind of thing that needs to be raised to the board?
I don't think it does, and I think it's because 30A very clearly states that it's a structural due process issue, procedural due process. Thank you.
Thank you very much. We will hear next from Attorney Blackman, I think. Yes, but let me start before your clock starts. This is the first SORB case I've heard, and of course the brief in this case is signed by your late colleague David Chennai, and I don't know if my co-panelists are in the same situation or not. I just want to acknowledge his excellence as a lawyer. He appeared before us innumerable times representing the board and was always so thoughtful and professional, and it's a great loss to our legal community that he's died.
Some hard shoes to fill in.
So with that, we will hear from Attorney Blackman.
Good morning. May it please the court, Jessica Blackman on behalf of the board. Just to begin, I would argue that to raise this constitutional claim, it should have been brought through a declaratory judgment because it's based on the general.
So if an individual has a claim in their case, they're not saying do it all the time, just saying the Constitution requires you, in my case, to have an expert. How do they raise that? Not a facial challenge to the regulations, but just says, where's my expert?
So in that case, at the hearing level, that offender could have raised
but
the
I thought there was something, I thought it was SORB's position and maybe been adopted by courts, that you can't raise a constitutional claim before the hearing examiner.
Right, but in this case, each individual has the opportunity to request their own expert. So
no, but that's not what I'm asking.
Right.
I'm asking if their position is, as a matter of due process of law, you must have an expert. This hearing examiner alone is not adequate. Can that be raised before the hearing examiner or no?
I guess not. I mean, I think it would have, I guess raising it at the Superior Court level would have been the first place they'd be able to do that.
An as-applied claim, like, I'm not asking you, Madam Hearing Examiner, to rule that expert evidence is required in every case, but at least in my case, the board needs to put on expert evidence.
Well, I don't think that.
Couldn't the hearing examiner have said, turned to board counsel and said, well, board, this looks like a pretty close case here. Don't you want to go get an expert?
I don't think that's
I know it's not done, but could
how it would be done. Yeah. I think it's up to the board to determine what evidence they feel they need or we need to meet that burden of proof.
Right.
And I think in turning on that, my primary argument is the legislator enacted the registry laws, created the board, and at that time required that the board be comprised of experts in the area of assessing risk in sex offender cases.
What makes them experts?
What was that?
What makes them experts?
So they required that they be experts that are knowledgeable and experienced in assessing and evaluating sex offenders specifically.
Well, on the day they're hired, what is it that they've done that gives them experience doing this?
Some are psychologists that have done, there's a certain amount of experts required for the board, not the hearing examiners, that's a wider range of people. But the specific board members that are required to be hired and maintained on the board
No, but the hearing examiners, do the hearing examiners have to be expert?
No.
Okay.
So the purpose.
So I'm going to ask you the question I always asked David Chennai, so I kind of know the answer. The board has said that there's a moderate risk of reoffense here. What percentage is that? What percentage risk?
It's based on all of the factors that were taken into a cumulative review.
Okay, so what percentage would a low risk be?
It depends on every single
So what
individual
percentage
sex
would a
offender.
high risk be?
I can't give you a specific number
Okay,
because
so-
it's not based on a specific number.
I see.
And the legislature didn't
I
require
see.
that.
So given that, why shouldn't they have an expert? All the articles have percentages in them.
Because those articles are what the experts on the board
But,
were
okay, fine. So if they
required.
could tell me the percentages from the articles and say this is a 17% risk or a 7% risk, I don't even know what high or low would be. High might be 5%. High might be 95%. I don't have the first idea. But surely high has to be a higher percentage than moderate, which has to be a higher percentage than low. And my question is, since you won't give us that, shouldn't an expert who actually knows about these things be the person to do the classification? And I'll add to that, anecdotally, I think every member of this court has seen cases that look a lot the same, but some are 3s and some are 2s.
And every case is different based on the facts of
I
that
couldn't
case.
agree.
So-
I couldn't agree more.
And the whole purpose behind making sure that the board was comprised of experts that do have knowledge in evaluating sex offenders and determining risk was that those experts then looked at all of the research that an expert would look at.
And so high, if
Those factors.
high doesn't mean a percentage, what does it mean?
High means, in that case, the facts alone and the application of those facts to each applicable factor equaled out to a high risk based on what factors
High
were
risk,
present.
a high risk.
If that's
So
what you're
I'm the
asking.
hearing examiner, and I have to decide, I've got these 3 buckets, 1, 2, and 3, and I have to decide what to put it in. How do I decide it's high, not moderate, if I'm not looking at the percentage risk? High means a higher percentage risk, doesn't it?
Correct, but it's not based on a percentage or an amount. It's based on a qualitative assessment of the facts of that case.
And why isn't that
There are-
completely arbitrary if it isn't tied to an amount? And why shouldn't we have an expert come in who actually knows about the percentages, since that's what they use in all the articles, and can say, oh no, I would not say this is 8%, because although people like X are 8%, there's also this, and that reduces it to a lower percent.
And the hearing examiners are utilizing those expert opinions and those studies in applying the factors and reading what that implicates: a higher risk to reoffend, a higher degree of dangers, a lower risk to reoffend because
Meaning a lower percentage risk.
it's really not tied to percentages.
I hear you. That's a huge problem for me, but I'm trying to figure out, you do agree that lower and higher refers to percentage of risk of reoffense. This one, 9 out of 10 times is going to reoffend. This one, 1 out of 400 times is going to reoffend. That's low, that's high.
Right, and the job of the hearing examiner is to analyze all of that information.
And they could write down the percentage, and then we'd know whether they had done something that counts as high or low.
It all depends on what factors are present and the facts of that case.
Okay.
But I can tell you, we have experts that testify in these cases all of the time. The offenders have the right to bring their own expert. And every
If they
single
can
time,
get, if they can get funds for it.
or if they're paying for it privately. And in those cases, those experts can only testify to factors relating to risk. They do not look at anything or weigh anything relating to danger.
Okay, danger is a separate question. I didn't ask you
It's a
about danger. I
requirement.
asked you about risk of reoffense. Dangerousness, I think, is supposed
But
to be
when they
based on
testify,
past.
they're indicating the same studies and the same results that are that the factors were promulgated on and that they were made and when they were enacted by the experts that sit on the board that have the same information that the expert testifying is. So instead of requiring an expert in every case, the legislature required that the board be comprised of those experts. They are there.
I wish they were hearing examiners. That would be great.
The board member, the expert, is the first person to review that file and make that recommendation of what risk and what danger the offender poses.
Can I ask, the Matthews v. Eldridge test requires us to consider a number of factors, one of which is the governmental interests involved, including the fiscal and administrative burdens of adding the procedure that the plaintiff asserts is necessary. Is there any information in the record about whether the board or how the board could cope with needing to put on expert evidence?
I think that would increase the cost tremendously in every case, requiring an expert. And the burden is also with an indigent offender is also, allowing for funds that the government is also paying for in both cases. So now you're requiring.
And it does that because of the liberty interest that's at stake, right?
Yes, but if you look at the comparison with SCP cases where an expert is required, the courts found that that liberty interest of indefinite civil commitment was a much higher interest than those that were at issue in the sex offender cases.
But don't you think that they have increased
They have.
the amount of liberty that they recognize
Absolutely.
as infringed?
And in order to protect the sex offender, the court found that instead of preponderance of the evidence, clear and convincing evidence should be required. So they safeguarded that. It still doesn't rise to the level of indefinite civil commitment, that liberty interest, but the courts have held that the liberty interests that are at stake in these cases and the procedural due process that's required is satisfied by the current statutory.
They didn't say, there's no holding since the clear and convincing evidence that says no expert continues to be required, right? We're being asked that, I think, for the first time. I don't know if it's raised the right way here, but we're being asked.
It's been argued, right, and it's been argued since then.
To the SJC, and there's a published decision?
No, but what I'm saying
not
is-
even a published decision from here, I think. Just, there may be some 23.0s.
Yeah, but there are numerous other, well, not numerous others. So what was brought to the court's attention was that standard of proof, which was lower, and it has now been heightened to protect those increased. I mean, that was the purpose of increasing the standard of proof, was that there was an increase in the liberty interest. But again, nobody has said that experts or that the legislative intent has changed or that the liberty interests are high enough that that expert is required like it is in an SDP case.
Well, opposing counsel says that. No court has said it.
I wanted to get clear on whether there's any law or board regulation that says the board needn't offer expert evidence in every case or in any case. I understand that that's the prevailing view and that it's never been held before that the board needs to provide expert, but is there any bar to it in existing board regulations or statute? I'm not aware of any. It's not a trick question. I just want to.
Could you just repeat?
Sure. Is there any statute or board regulation that says the board can't offer expert evidence?
No, absolutely not.
Or can't do it in every case?
No, there's nothing that says they can't do it. It's discretionary.
So we wouldn't have to invalidate any statute or regulation in order to rule for the Mr. W.
Yes. And I would argue that it goes towards the burden of the choice as to whether or not the board is offering expert evidence goes to not the burden of proof, but what evidence the board wants to submit to meet that burden.
I had a question about one of the other issues in the case, which was the hearing examiner's lack of specificity about the weight to be assigned to particular factors.
Yes.
Factors your brief in a footnote, I think footnote 11, says there was no need to assign a particular weight to factors 20, 21, or 22. Factor 20's text says the board must consider the number, types, and frequency of a sex offender's diverse sexual behaviors in the weight applied to this factor. So shouldn't, where the reg itself speaks in terms of weight, and shouldn't the examiner say what weight based on the number, types, and frequency of the behaviors?
So I do agree that that was a misstatement in that portion. The other two factors that were listed are factors that do not require weight. And I'm not saying that this requires weight, but it allows for different weight to be given. However, while the hearing examiner is not explicitly required by law or the regulations to include that weight, so long as the application is sufficiently explained by the examiner to permit effective review of the decision. And that was held in Joe 526-197. I would argue when you look at this entire case as a whole, where proper application of all of the other factors was made, where 3 high-risk factors were applied in this case.
What was 5261? Was that like a harmless error, kind of?
Yeah.
Okay.
And so long as the board, or so long as the court is able to make a reasonable, sufficient determination.
What about factor 22 that says offenders against 2 or more victims present an increased risk of reoffense? Is the board's position that that's binary, so that if you have 2 victims, it's a certain amount of increased risk, and if you have 15 victims, then it's the same amount of increased risk?
I would argue.
It weighted based on the number.
Right. Again, I don't think it specifically requires an amount of weight. I think it may be something that is analyzed by the hearing examiner, and if they have 15 victims, then that may come down to more danger because they're weighing that against the potential for further victims or the harm that's already been done. But again, it's not required, and all that is required for that to apply is that there's more than 1 victim. The same with factor 21, which is different victim types, or transverse is different. But I would argue when you look at everything as a whole, the court can determine or make that finding, even with factor 20 not having weight to it. I think if you look at it in the grand scheme of things, this is an offender who did recidivate. He reoffended after being convicted, and with only 7 years offense-free time in the community, he was still given a reduced level. I think that's the most important thing to keep in mind here, is that even with only 7 years of offense-free time, the fact that he reoffended in this case, the hearing examiner still found that he warranted a reduction.
Does the reg specifically state that incarceration for non-sexual offense doesn't count as time in the community?
Yes, a non-sexual violent offense.
Yes,
So
but it says that like flat out. That's not a judgment call.
no. So factor 29, offense-free time in the community begins on the date of an offender's most recent release from custody for a sex offense or a non-sexual violent offense.
That's the 2016 regs. I think the 2025 regs take out the non-sexual violent offense, but then they put it back in by saying that time spent out of the community, like being incarcerated for something, does not count as offense-free time in the community.
Yes. Well, I would note, yes, but in this case, also, the 2016 regs are the ones that are at issue when this hearing occurred. The 2025 regs only just went into play. So based on those, at the time of this hearing, the hearing examiner comported with that requirement and giving him weight. And honestly, she provided a reduction in his risk, so she clearly considered that as a substantial reduction or a substantial benefit to this offender when compared to everything else. 3 high-risk factors, and 10 additional risk-elevating factors. But what he did provide in mitigating evidence, she found sufficient enough to reduce him.
So I have one other question for, maybe there are others, I don't. Is the board informed when someone recidivates who's a registered sex offender?
So the board is informed upon conviction for a sex offense.
If they commit another sex offense?
Yes.
Okay.
We receive notification.
So I have more of an observation than a question. I know that SORB wants to get these classifications right too. I'm sure you're all aware of the consequences of these classifications for these people, which are really extremely grave. I suggest that someone at the board should look at the numbers of people in each category and see what their actual rate of reoffense is, maybe divided by hearing examiner, maybe not, I don't run your agency. But saying we don't have money for it, it cost, you could run it on a computer in 20 minutes. I think it might be valuable not just for litigation in the future, but for making sure that you're using a system that works to try to figure out whether the people you're saying are level 3 are higher than level 2, are higher than level 1, or not, because then we might have some data to go on. That's all.
Heard.
All right, thank you both very much. Excellent arguments, and I think we understand them, and the case is submitted. The next matter, and final matter for the day, is number 2591, DCF versus, I'm just going to say father. These are, this is an impounded case, and so pseudonyms for parties' names, such as child, mother, father, would be ideal. I gather the appellees are splitting their time. I have been told that Attorney Coral will get 8 minutes and Attorney Penta 7. Is that right? In that order? Okay. And we will hear first from Attorney Gioia.
Good afternoon, members of the panel. Ana Maria Gioia on behalf of the appellant father, and may it please the court. Before we begin, I'd just like to note that father is present in the gallery. My client is asking this court to vacate the order of termination and remand for further proceedings. The evidence of unfitness falls short, and let me tell you why. I will be addressing directly the sexual abuse allegations, the non-compliance of DCF's plan, the child's needs, and finally the reunification plan. As far as the sexual abuse allegation are concerned, there is no dispute that father did not present well as a witness on trial. The trial court found father's testimony as mendacious and took issue with father's demeanor during trial. The court made numerous findings regarding his credibility, or in the judge's opinion, lack of credibility. Straightforward, the trial court believed that father was a liar, which the trial court is allowed to make credibility assessments. But the burden is still on the department to show whether father was unfit. And not being a good witness does not rise to the level of unfitness, because once you peel back the layers of this evidence, you do not have enough to render father unfit. As to the allegations of sexual abuse of a 10-year-old child, the judge went to great lengths to discuss the allegations of sexual abuse against father and this substantiation letter that father signed. But there was no evidence of this letter. Father testified that he signed a document, but it is unclear what he signed and, more importantly, what this document actually says. The court relied heavily on a document that was not presented as evidence and yet attributed father's tears as he signed the letter, not only as proof that father knew what was in the letter, which is the allegation of sexual abuse, but that these tears were a form of admission, that he admitted to the allegations and thus proved his guilt.
So the main ICPC report says that the father acknowledged that he signed the substantiation letter.
But
And he reiterated that it couldn't be used against him legally by the state of Maine because he wasn't charged with a crime.
but that is correct. There was no,
Right, but doesn't that indicate that he kind of knows what people are presumed to know the contents of what they sign, and he had some idea of what this was about, didn't he? Couldn't the judge find that? Is the relevant question.
well, I mean, the judge could make credibility findings as towards the father, but the fact remains that 12 pieces of exhibits were introduced at trial, and not one of those 12 exhibits was father's carry from Massachusetts, from Maine, or from another state.
Does the name substantiation letter not convey that it is substantiating the allegation? I mean, I'm not sure, that's not a phrase I've heard in Massachusetts law, I don't think. Maybe my colleagues have. But a substantiation letter presumably substantiates the allegation. And the statement that it can't be used against you suggests that it's inculpatory, but can't be used against you.
It could be, but we don't have the letter. We never saw the letter. Furthermore, there were no police reports introduced into evidence regarding this allegation of sexual abuse. There was no docket sheet reflecting that he was criminally charged. There was no evidence of the sexual abuse. Regarding the noncompliance of DCF's plan, the department tasked father to, quote, enroll and complete sex offender therapeutic program. Please call New Hampshire State for referrals to providers who offer this services. The court faulted father for not following through with the service, but father never admitted that he was a sex offender. There was no evidence that he was a sex offender. Furthermore, the court also wanted father to provide proof of sobriety, but the task was based on mother's testimony that in the 6 months she lived with father, in the beginning of 2013, transcript page 102, mother observes father to drink to the point of intoxication every night. This is what mother testified to on transcript page 123. There was no evidence or testimony that father had current issues with alcohol abuse. DCF had plenty of interactions with father. They never observed father to be blurry-eyed, incoherent, slurred speech. No evidence that father was ever under the influence with his interactions with DCF or during his supervised visits. And this court, in adoption of Yale, held that a parent's noncompliance with DCF's plan is not dispositive of those, does not appear related to any clearly identified deficiencies. So the fact that there was no evidence to support that father needed a sexual offender program or that he needed to prove his sobriety. Regarding the child's needs, the child was diagnosed with behavioral health issues and chromosome deletion syndrome of chromosomes 11p and 11.2. That's an exhibit page 29. The child also had an IEP for her ADHD, as well as trauma and stress related, and she was in counseling once a week for 30 minutes. But although, furthermore, the father specifically addressed how he would deal with the child's IEP and goes into great lengths to discuss it, exhibit appendix page 129. Lastly, regarding the reunification plan, the trial court improperly placed a disproportionate amount of weight on the child's pre-adoptive home because she was with her siblings. As your honors know, these types of cases are incredibly difficult. It is very hard to find foster homes that take siblings. It is even rarer to find a pre-adoptive home that is willing to accept and adopt a set of siblings, as in this case. But that does not change the fact that father is still fit to raise his daughter. And yes, this child was removed from her mother's care in November 9 of 2020, and she's been living with her 3 siblings since January 6, 2023. So they have been living together for a very long time. But the department changed its goal from reunification to adoption on October 14, 2021, and father wasn't located until June 2022. In that time, the department focused exclusively on supporting the pre-adoptive parents because they had agreed to adopt all of the siblings. And the SJC in adoption of Hugo made it clear that sibling relationships is just one factor, but it cannot be dispositive, even if the siblings wish to remain together. Lastly, Your Honors, I will simply say that if a parent is found fit, the reunification plan is left to the experts, and in this case, that was the department. It is unfair to require my client to have come up with a reunification plan and tasked him with the responsibility of creating it and presenting it. For these reasons, I submit to the court that we are asking that this court vacate the order of termination and remand for further proceedings. Thank you, Your
I
Honor.
see no further questions. Excellent argument. Thank
Thank
you
you.
very much. We will hear now from Attorney Corral.
Good afternoon, Your Honors. Tracy Corral for the Department of Children and Families. If it may please the court, Your Honors, this is a very difficult case that turns on a little girl who had very little contact with her father over the course of her life. The trial judge gave the evidence very close consideration. I think that's reflected in her findings, and did not abuse her discretion when she determined that a constellation of factors provided ample evidence for the termination of parental rights. The department requests that you uphold the decrees, or the decree in this case, and allow this child to remain freed for adoption. Your Honor, I would actually like to start with the constellation of factors, and I'll reach the issue of the sexual abuse allegations after that. Your Honor, there were many factors that demonstrated this father's inability to meet this child's needs, most of which were unchallenged. Here, the court found that the father had a history of drinking nightly to intoxication. Testimony by the mother in this case was deemed credible. Father's testimony on the subject was not deemed credible. So the court did have evidence in front of it regarding father's substance use. I would also point out to Your Honors that father told the ICPC social worker from Maine that he used marijuana 3 to 4 times a week. And when he came to court, he said that, I believe he said he used marijuana maybe once a week or less. So there was differences in what he told various people about how much substances he was using. The department asked him for proof of sobriety. He did not provide any proof of sobriety. The father has a history of mental illness and was receiving Social Security disability income from that. He was not in any kind of treatment and had not seen a primary care physician or any physician at all in 10 years. I think he saw a physician once in 10 years.
I want to ask you about visits.
Yes.
Your brief says that when the department asked the father to visit the child in person, he missed half the visits.
Yes.
Did he miss any scheduled visits?
Yes, they were scheduled. Or no, he just didn't schedule the visits. There were, he was entitled to a visit every month, and the department the department social worker attempted to email him and arrange those
All right,
visits.
so he didn't set up visits for
He didn't no-show.
April, May, June, and July, I think.
Right.
Is it fair to refer to those as, I mean, it may well give rise to an inference of lack of interest in parenting the child, but is it fair to refer to those as missed visits, maybe missed opportunities for visits?
I probably could have been more elegant with my language, Your Honor. But on that subject, you have a child here that he has seen in person 7 times since she was a toddler. This is a child, as counsel referenced, with special needs. She has issues with some violence, fecal incontinence. She has learning disabilities. She requires substantial therapeutic supports at school. She requires support at home with behavioral modeling, as well as just general guidance, and I would assume a lot of patience. I think it would be fair to infer from the situation. And this is a child who it would be important for a primary caretaker to get to know her, and this father did not inquire about her special needs. He did not attend all of the visits to which he was entitled. He did not attend foster care reviews or court hearings where he might have learned or heard about her special needs. So he had ample opportunity to learn this child's special needs and did not take advantage of those opportunities. And with a child with these kinds of needs, I think that is something that this court relied upon in deciding that he was unfit, and it was not an abuse of discretion.
Do you know if the child is in the same placement as at the time of trial?
Yes, she is currently placed with her siblings in that same placement.
And turning to this risk of sexual abuse.
Yes.
I mean, that was, the substantiation letter was in 2009. Is there some point at which that it becomes stale and insufficient to infer that the father still presents that risk?
I think it's a fair question, Your Honor, and I would suggest that there were a number of there were a few different pieces of evidence that supported the court's finding that he posed a risk of sexual abuse, or he didn't. The situation did. The situation posed a risk of sexual abuse to the child. The first was, of course, the substantiation letter, and I will point out, finding a fact, I believe it was 81, where the court did find that he was aware of the allegations that were contained in the...
What's a substantiation letter? I've never heard of it before in Massachusetts. I know this is Maine, but what is it?
I believe it is a letter indicating that our Maine counterpart finds that there is a preponderance of the evidence to support the allegations.
So it's a letter from the state of Maine, you think, saying we find, it's like our allegation is supported, is what we would say here.
Yes.
They're saying we find this allegation substantiated.
Correct. And we do actually have a substantiation category. But
so it is, oh, okay, I don't know about that.
Yeah.
But what does it mean? It's a letter from Maine to the
perpetrator.
Alleged perpetrator.
Yes.
What does it mean to sign it?
That I'm not clear. I think I'm comfortable to say that he acknowledged the receipt of those allegations and and he acknowledged that they were substantiated. Beyond that, I'm not comfortable.
If that's the same as saying he acknowledged that the 51A was found supported, what does that demonstrate? It is supported. Or it was substantiated, whatever.
In this case, the judge was very careful in how she presented this, and she said that it was, in this case, she said that it was, I'm sorry, I've lost my train of thought completely.
What the substantiation letter was. See, I'm just trying to figure out, is it treated as an admission of guilt in the judge's opinion? And is it an admission of guilt? Now, if you said to me, I signed a letter saying I did this, okay, that I understand.
I don't think she treated it as an admission of guilt. I think she treated it as these allegations were unchallenged.
Well, why does it matter then if the father signed this letter or not?
I think
Why
it
does
matters
his
because-
receipt of the substantiation
Right.
do anything?
I think in part it matters because the court found his testimony around the letter and the allegations in the letter and what he knew about the letter and the allegations, she found none of it was credible.
Okay, so he knew that it had been substantiated, but as you know, supporting something here isn't a finding that it happened. It's a finding that there's a reasonable basis to believe
Right.
an allegation or something, you know.
So there were a couple things, and just to get back to the first question I think you asked, the substantiation letter, certainly the court did rely on that and the fact that it was not challenged. He did not challenge that finding. The fact that his live-in partner also had allegations of sexually inappropriate behavior with her children.
I'm not
which was
saying
not
there isn't
challenged.
other evidence. I'm just focused, I mean, in fact, opposing counsel in the brief argues only about this
Right.
allegation. So I just want to understand where the judge concluded we were with respect to the truthfulness of the allegation and on what basis.
I think I would just point out to your honors that, as I said, I don't think she necessarily found truthfulness of the allegation. I think she found that placing this child in a home with two people with unchallenged allegations of sexual abuse and no treatment, no mitigation, posed a risk of harm to the child.
Unchallenged allegations.
Neither person challenged the allegations. They didn't seek
Oh,
the
meaning they
main-
didn't seek review of the substantiation or?
Seek review of the substantiation, and his live-in girlfriend did not go to court on the allegations. He testified about that at length, that she did not go to court because the social worker told
Well,
her
I'm
she
more
didn't have
focused
to.
on the allegations against the father than the.
Sure.
I'm not saying it is irrelevant, given that it's live-in and so on, but I'm just trying to make sure we understand what this is, because
Right.
I don't exactly understand what it is.
It is a little bit of a different animal than how we do things at the department in Massachusetts. I agree. But I think it's fair to say that it represents finding a preponderance of the evidence, which, by the way, is the standard for subsidiary
By a
findings.
preponderance of the evidence, what, though? By preponderance of the evidence, there's a reasonable basis to believe is less than a finding that by a preponderance of the evidence, the thing happened. So we all the time say, oh, the allegation was supported, but then when you read the case law and what supported means,
Right.
it's a lot less than a finding by a preponderance of the evidence that it
Right.
happened.
I think the court here took into consideration the nature of father's testimony and how he presented on the witness stand, how he...
That doesn't mean that he engaged in sexual abuse.
No, I think it means, but I think she was gauging the risk of, the potential for risk of harm to the child. And that is how she characterized her finding, was that there was a potential for risk of harm to the child. And so that, I don't think she made a finding that he engaged in sexual abuse. I think she made a finding that there was a potential for risk of harm based on these factors.
Okay.
But I would just reiterate, and I know that I'm out of time, I'll make it very brief. There were a constellation of factors, and if I was going to rest my hat on a single factor that Your Honor should really examine closely, I would say that this child had substantial needs. This child needs very dedicated parenting that is going to give her the guidance and the modeling so that she's able to be successful and do the things we want our kids to do. And his father did not educate himself on any of those needs. He's not prepared to parent this child, and he wasn't at the time of trial, and the court got it right when, and she did not abuse her discretion. There's plenty of evidence on that factor. So with that, I will rest on my brief, and thank you very much.
Thank you, and I see no further questions. We will hear now from Attorney Penta on behalf of the child.
Good afternoon, Your Honors. My name is Attorney Michael Penta, and I represent the appellee child who requests this court affirm the juvenile court's decree and judgment in all respects. I was prepared to focus on the best interests with regards to the termination as well as the post-adoption contact, but I think there's some unanswered questions, obviously, with the sexual abuse accusations. And those are serious accusations. We have to look no further than the case you just heard. But I think there is a different dynamic in this case, how this plays out. When a parent is accused of sexual abuse. A state agency recently investigates that as part of their home study and denies the home study based on that accusation. The fact that there is another household member who is also accused of sexual abuse raises a red flag. And that might not substantiate that this actually had occurred, but it does invite the department to offer services to determine whether that parent is in fact a sexual abuser or not, and whether or not there's a remediation if he is. This also goes to the alcohol and intoxication, that I do remind the court that I don't believe, other than the sexual abuse substantiation letter, there's been any challenge to any of the other findings of facts. So the fact that father did drink to intoxication while he was with mother and her child at the time is not challenged. So again, that is a reasonable task for the department to ask that a parent demonstrate sobriety with that history of alcohol abuse. And when a parent does have untreated mental health diagnoses, it's also a reasonable expectation that the parent would engage in some form of therapy.
Assuming there's a nexus between these and ability to parent.
Well, that's the case here. He's never parented this child, which goes to why it's in the best that even aside from the accusations of sexual abuse, the concerns with alcohol abuse and mental health concerns, this father has never been a caretaker for this child. He has never been alone with this child. He has visited this child maybe a half dozen times as his entire life. He's never provided with any direct material and financial support. From 2015 to 2022, he had no contact with this child, despite having means to contact this child through his sister, who was very close friends with the mother. In fact, that's how the mother was able to contact the father to report that the department had removed the children. Since 2022, he had only 5 in-person visits with the child, and in 7 total. He has had no contact with the child 4 months prior to trial. And by his own admissions, his relationship was just budding with his then 10-year-old daughter. So there's been no history of parenting this child. Visits are okay, but they're very artificial, especially when they're supervised.
How old is the child now?
12 years old.
Is that the age at which a competent child can disapprove
withhold consent, I should
an
say.
adoption?
Yeah, yes.
And is it your understanding that the child's cognitive abilities allow them to participate in that way in this case?
Well, absolutely, Your Honor.
You've met with the child recently?
Saturday, February 28th, just 5 days ago.
And the child is still in the placement?
Still in the placement, along with the siblings.
And it's still a pre-adoptive resource?
Oh, yeah, this is the only thing that's standing in the...
Okay.
And so the father's relationship with the child is superficial, very little. I mean, as I just explained, there's been absolutely no interest until recently in the department's involvement. And even then, as we've heard, there was, as a judge found at least, there was sort of an undescribed way he was trying to describe how he was asking for visits, and was really asked for 1 visit for a long period of time and never responded. So there's that, but there's also, I don't want to belabor my limited time, all of the other diagnoses that both of my counsel had described for my client, but she has very special needs.
No, it's obviously in the judge's...
It's in the judge's findings, I'm sure it's in all our briefs, and it's been discussed today, no more to reiterate all that's been said. But what it does demonstrate is that a child with special needs needs a parent who is interested in learning about the child's special needs. And here, he never asked about the child's medical and educational needs. That's sort of, whether a parent believes they can or cannot ask the department seems a little incredulous, when that's part of the hallmark of what a parent would do, is ask how their children is doing and what is my child's needs, especially when you're aware that your child has diagnoses. This child does not need a parent who's going to give her a hard time if he gives her a hard time. He needs a parent who's going to address her with patience, with dedication, attend to her emotional supports. And most certainly, I think not to overlook this, is that, as counsel said, it is any silver lining in the foster care system is whenever you can find a family that's willing to take siblings. And in this case, they take 4 siblings, all with varying degrees of special needs. And that is a very strong bond that she has, not only developed with the foster parents, but also with her siblings. They've never been separated their entire lives, with the exception of a few months with the oldest sister. So you have a child who is in a loving, pre-adoptive home with her siblings, an adoptive home that is meeting all of her needs. And that's why her best interests are served by the termination decree, which, again, is well within the discretion of the trial judge to determine. The best interest of the child is a discretionary decision that is entitled to substantial deference. With my limited time, I'd like to also say that the post-adoption visitation or order deferring to the discretion of the foster parents was also within the trial judge discretion and also serves the best interest of the child. There was no evidence presented that an order is necessary. Now, the judge did find that it's in the best interest to have contact. That's why she ordered the department as an institution to provide 3 visits a year. It's a different dynamic when you're dealing with an adoptive family. At that point, they've become the child's legal parents and have all the same rights and presumptions that they'll act in the child's best interest. To answer your question, Justice Rubin, child is 10 years old at the time of trial. She was quite capable and competent of asking whether she wanted more or less contact with her biological father. The pre-adoptive parents have a history of recognizing and supporting biological parents' rights. They entered into open adoption agreements with this child's mother and the siblings, well, they're all the same mother, and an open adoption agreement with the other siblings' other father. So that, I think, demonstrates that the parent is open to ongoing contact if it's in the child's best interest. And there's really nothing that was presented that they would act otherwise. So unless there are any questions, I'll rest on my brief and ask this court.
I'll just ask one question. Are you aware that there are regulations issued by the Maine DSS or whatever they may be called now that talk about the substantiation process the way that our DCF has regs?
Are you talking about in Maine, you mean?
Yes.
I'm not aware of
we could determine what a substantiation letter meant in 2009.
I'm not aware of what their terminology is, whether substantiations are equivalent to supported. I apologize, I didn't really look into it because I looked at from the lens that where there's smoke, there might be fire, and it's worthy of further investigation, that there is no dispute that father signed something that this child accused him of doing something horrible, and that the state of Maine was asked to do a home study through the Interstate Compact, which is very encouraged out of the adoption of Knox, to see whether, in fact, when you... So the answer to the reasonable question is just that was one exercise they did, which, again, Justice Sachs, is why it's not stale. That letter's not stale because it was the basis for the Maine's denial of the ICPC, which was done, I don't know the exact date, but it had to have been done after father came to the surface in 2022. So it was when this case was pending, when the care and protection was pending. So it's certainly, as I think I said in my opening remarks, I don't know the terminology, but the underlying facts show that he was accused of doing something. It was the basis or part of the basis for denying his home in an out-of-state home study. And therefore, it was well within the department's reasonable discretion to add that task to an action plan to get to the bottom of it. We're not saying, and I'm not standing here before you to say that that actually happened, but it certainly is not something we just turn a blind eye to when you have a daughter who's of the same age as the girl who accused him of those horrible things. And also, there's another person in the home, a long-term living girlfriend, who's also been accused of similar acts. So it's not something I think... we have a history. It's worthy of further investigation, and father had an opportunity to testify to that at trial, both in direct and cross-examination, and at the best left more questions than answers on that topic. And so I do submit to this court that the letter itself is not being presented, by me at least, as substantiating that it actually happened, but that something happened, and that something required much further investigation than, and I apologize than what the term actually means, because even if it means much less than, I agree, if it was an accusation letter versus a substantiation letter, I don't know if the terminology makes a difference, but the underlying substance of what was being accused certainly warranted further investigation, and by not engaging in a sexual therapy or sexual abuse therapy, which could have a therapist elaborate on that. And I also, I know my time is up, but on that letter too, if the letter was exonerating, Trial counsel, certainly for father, could have presented it
Well,
as a
but the
piece of
burden,
so-
the burden is on the department, of
Well, I
course.
think the burden's on the department. That's what I was saying, it was exonerating. So if maybe it was maybe strategically what that letter meant. We don't have the benefit of the letter. We have the benefit of the underlying substance of what that letter represents that presented itself in many different ways. As I said, with the ICPC denial, with obviously by having that accusation and the basis was certainly invited more further inquiry. And when you ask the parent about that and their answers, and the judge finds their answers elusive, evasive, uncredible, again, it raises more questions than answers as to even the sincerity of which he took the accusations and willing to get to the bottom of it. So,
I see no further questions, and your time has expired. Thank you very much, all three of you, for excellent arguments. These are very hard cases for us, of course, the hardest really that we see, and so your assistance is really meaningful to us. So thank you very much. The case is submitted, and that brings us to the end of our sitting. I would like to thank the court officer and the court staff for their excellent assistance, and we stand in recess.